Any mention?
Please, Lordship. Beg to mention item number 69, Lordship.
Yes, my lord, I am little hard pressed because there is an order of stay operating against me.
69, which one?
Is that ex-serviceman association matter, Lordship?
Which one?
69, Lordship. Vijender Singh.
Who's Vijender Singh?
He's one of the employee.
He is one of the past employees of Assam Rifles, residing at a far-off place in Haryana. He files a case here, challenging some decision which has been taken in Kerala. Regarding
Matter about?
Matter is with regard to registration of an association. There is an association of the ex-servicemen.
Okay. You are appearing for?
I am for respondent number 1. Yes.
Oh, that 5 by net organization.
So that is the thing. In fact, my lord, I was informed that they will be doing it, so that's why I came.
So,
but
Mr. Khera was travelling, Lordship. There was some delay in his travel. Kindly allow us just a short date, Lordship. We'll take up, Lordship.
Then you have to pay senior counsels.
Lordship, was unforeseen circumstances, Lordship. Kindly allow us.
You have objection? My lord, I can't object, my lord, because the counsel is absent, but otherwise there is some urgency, my lord. That's why I am saying.
Where Dr. Mozika?
He's currently unable, Lordship.
In that case, my lord, can it be on 10th of September?
10th of September.
Lordship.
Yeah. On the premise due to the unavailability of the arguing counsel, let the matter be listed on 10th of September. Is record presence on the trial. First time you're appearing?
Yes, today I am appearing for the first time.
Okay. Right.
Obliged.
Yes.
Lordship, consent of the other side. I beg to mention item number 70, Lordship.
Yes.
Lordship may take up matter after 3 weeks, Lordship.
Where's yes, Amartya?
Lordship, we don't have objection. We're just a formal party.
2 weeks, 3 weeks. Who's the other main party? Mr. B.K. Singh?
Yes, Lordship. We have taken consent from him.
Okay, yes. 3 weeks, right? Okay. Yes.
Obliged, Lordship. Then interim may be continued, Lordship, in item number 70.
Yes.
But I may be allowed to make a mention for an urgent unlisted matter, my lord, concerning the termination of service for today, my lord.
Already terminated?
No, my lord. It'll be given effect to today, my lord. The impugn order, my lord, shall be given effect. It's 14th, my lord. 14th, my lord, Saturday, Sunday being a holiday, my lord, we cannot.
Service.
My lord, it is in Indian Institute of Management, my lord. He's working manager, admission.
Termination.
Termination. He's basically, my lord, not a termination, but he's a probee, my lord. But his contract has not been, his appointment has not been extended any further, my lord.
So,
on the basis of a complaint, my lord, relying on a complaint which was made sometime in January,
yes,
my lord, and they partly relied on that complaint to, my lord, issue the impugn order. And on top of it, my lord, there was no show cause given to me. So in that view of the matter, my lord, the entire exercise becomes punitive. That is
who will accept notice? You have served notice?
That will serve on the union, my lord, because
has been
filed. We are in the process. It's almost ready, my lord.
You take a chance.
My lord. Obliged. Thank you.
Please, Lordship. Lordship, I beg to mention item 66, Lordship.
66.
Yes, for respondent number 9,
Mr.
Lordship.
Shilla?
He's out of station, Lordship.
He's never in station only. He's not based in Shilla. So?
He is here, your Lordship, during Monday, Friday, Lordship.
During Monday, Friday, so we have to wait for him.
No, Lordship. This is some personal difficulties.
That's not that's the ground for adjournment. We tell Mr. Shilla that.
Lordship.
What that cannot work to your convenience. You prepare the matter. Yes.
Lordship.
No objection.
2 weeks time we've given, Lordship.
How many times have we adjourned this matter? At their behest. How many times?
First time, Lordship, from our.
First time?
Yes, Lordship.
Okay, 2 weeks, yes. It's not a fresh matter, yes. Yes.
May I please, Your Lordship? Item number 62 and 63. Your Lordship, my senior conducting counsel is on leave due to some bereavement in the family, Your Lordship.
Who? Ronnie? Okay. Where's where's Muzika?
He's currently on legs.
He's already heard part, right?
Yes, Your Lordship.
Okay, after?
1 week short accommodation.
Okay, 1 week is due to the bereavement of senior counsel appearing for the appellant in item 62. Let this matter list after
And 63,
1
Your
week.
Lordship.
63 list together. Yes.
Item 4 from the supplementary list, Your Lordship.
Supplementary list. Hearing.
Yes, Your Lordship.
Which one?
Item 4 from supplementary list.
Where's Mr. D?
Still on leave, Your Lordship.
Where's what's her name? She object vehemently. Miss what's her name? Sutunga. Where's she?
I am here, Your Lordship.
You're there.
Yes.
You will have no objection.
No, Your Lordship.
When?
Next week, Your Lordship.
After 1 week, yes, due to the as the counsel for the respondent number
3 and 4, Your Lordship.
it was on leave. Yes. List after 1 week. Yes.
Much obliged.
Please, Your Lordship. Lordship. Item number 72, Lordship. Let this matter come after 2 weeks. 72.
72.
72.
What is this, arbitration matter?
Lordship, it is matter relating to cancellation of my enlistment as a contractor.
Blacklisted.
No. They have cancelled my enlistment. They have listed, then later on they have cancelled.
No objection.
No objection, Your Lordship.
When? After 6 weeks.
Lordship, 2 weeks, Lordship.
Okay. 2 weeks. I will give you bonus 3-4 weeks of no problem. Yes. Yes, follow.
For hearing items, my letter is 61. Item 71. But this pertains to disability
It is otherwise is fixed on 3rd of September, madam.
4th of September?
This was somehow
4th
of September, madam.
3rd.
3rd, madam.
Is that correct?
I'm not aware of that, Your Lordship.
Correct. Matters. As submitted by Mr. B. Pathak that the other similar connected matters listed on 3rd September for hearing.
It is for hearing, madam.
Then this item 71 together, yes. On 3rd September. Yes.
My lord. My lord, item 64 also hearing, my lord. Today some difficulty, my lord, is there. Can it be next week, my lord?
Yeah, after 2 weeks, yes. Yes.
After 2 weeks, my lord. 64.
Okay.
Right.
Supplementary list item number 1.
May it please, Lordship. I'm praying, Lordship, if this matter can be passed over for some time. Senior counsel is representing the Meghalaya Bar Council in a division bench matter currently.
Meghalaya Bar Council meaning?
In one division bench matter. Yeah. So let it come after some time. Since there is an interim prayer.
Yes.
Yes, Lordship.
Item number 2.
May it please, Your Lordship. Your Lordship, this is a case of debit freeze of my account pursuant to 7,826, Your Lordship.
7,826. What amount lying in your bank?
Your Lordship, as per the account statement at Annexure 2, page 18, Your Lordship. This is the account statement until the date of...
No, how much money is there in your bank?
Your Lordship, this is a salary account. So salary keeps crediting to my account. Axis Bank, Your Lordship.
Axis Bank. Who's appearing?
No one's Your Lordship, notice has to be issued.
No, for the state.
I'm appearing for the state.
Yes.
1 and 2, my lord.
Yes. Okay. But
Lordship, there's an interim prayer also, Your Lordship.
How will you have interim prayer now?
Your
Let the
Lordship,
bank come with instruction, you serve notice and defreeze your account. Okay?
Right.
Yes. But MS is in the council petition issue notice. MS where bank is present on behalf of Except notice on behalf of respondent number 1
and 2, my lord.
and 2. Stop. Notice issued to the remaining respondents within 3 days. Stop. Just after 2 weeks for further orders.
Hello,
Once you manage to serve them, we'll defeat the account.
Hello, pleasure.
Yes.
3.
See, here I am seeking for a direction for approval, for the approval of the appointment of the petitioner, lordship. My lord will kindly see that last page, lordship, page 38, lordship.
Page?
Here the petitioner was appointed an assistant teacher, lordship, in Melapara LP school, lordship.
Page 38.
Page 38.
30 or 38?
Last 38, lordship.
Okay. Yes.
My lord, if my lord will see that 3 paragraph from the bottom, lordship.
Yes.
That sir, Melapara non-gov lower primary so-and-so is a single teacher. So the SMC appointed Sri so-and-so being was placed in the first waiting list in the interview for the post of assistant teacher who was conducted on so-and-so by the SMC of Melapara so-and-so, and Sri so-and-so joined as a assistant teacher of Melapara on so-and-so and has been continuing in his service till date. As per the statement of parent guardian, he is regular and punctual in his duty. It is also forwarded that on the spot verification, the SMC president, secretary, members and parent guardian of the students' parents are given me a written request letter to the higher authority of the education department for the approval of the appointment.
So why has not been given approval?
My lord, that the approval is pending before the...
Why? What be a reason? It can't be pending just for the sake of pending.
Well, that is why, lordship, because this is the letter issued by the DSEO, District School Education Officer.
Yes.
Because the director had issued letter to the District School
So what is the
Education.
reason for the matter being kept pending?
They have not furnished any reason.
Someone else is already occupying your post.
My lord, no, my lord, because in year 2021, that somebody has been appointed, because the petitioner was also part of the said interview. Now that parties, the person who was appointed, after verifying found that she has produced a fake OBC certificate, then consequently he was terminated, lordship. So since managing committee is a party, let it notice be issued, lordship. In the meantime, they can bring the instruction.
1 to 5.
Yes, lordship.
Yes, heard Mr. S. Shane issue notice. Mr. Kimi Varaksa General GA, except on behalf of 1 to 5, notice to issue to respondent number 6 within 3 days, after 2 weeks. Yes.
My lord, only one. In the meantime, pendency of the writ petition shall not be a bar, lordship. In the...
Just let them see, issue the common instructions first.
Lordship.
Daily list item number 1.
Pass over.
Yeah, please, your lordship. Your lordship, the conducting counsel is out of station, your lordship.
Who is the conducting counsel?
Senior advocate SP Mahanta.
You're there. So, it's not for final hearing today. Yes. Why? Why are you making a submission?
Yeah, no, your lordship, because he is out of station, that's
So
why.
why are you making the submission? What's it for today?
It's admission hearing.
Admission hearing today?
Yes, your lordship.
Yes.
Come up for hearing, lordship. This matter come up for hearing.
What do you mean come for hearing? It's not been admitted as yet?
My lord, today is fixed for admission.
Yes.
In this matter, and we have filed the additional affidavit.
What have you filed?
We have filed on 14/8, my lord.
Who's respondent number 7? Who's number 7? Who's number 7?
Just check the order sheet. Just check.
Petition करना चाहिए. Respondent number 7, whom? Number 7 is acting CM. Who's the acting CM?
I think my friend is.
Yes, your honor. We are respondent number 7.
Where's the affidavit? See the last order.
Sir, I have not received.
Whenever there's a matter fixed for the next day, a junior should see what the last order passed, so you'll know where to take it from there. You understand? You just come blind to the court. It's the learning process. You have to know what the last order passed, and now it's online. Before other days, juniors had to go physically to the section and plead with the legal assistant, just get a look at the last order. Who know what's it coming up for? What's the last order? Read it out. Read out the last order. Yes. Don't have the last order. Order sheet indicates that affidavit to bring on record certain documents on number 7 yet to be filed. Your name?
Your Honor, Didas.
Mr. Didas, who's appearing. Mr. Didas' vice, Mr. Espinosa, the Senate Counsel, has no instructions. We listed after 1 week. Yes. You put the affidavit should be on board on the next date. Yeah.
44.
I'm querying for the protection and seeking a passover.
When?
At the end of the board. At the end of the board.
End of the board?
Yes. Passover.
What's it for today?
Admission.
This is for hearing.
Admission hearing.
Admission hearing.
You ready?
Your Lordship, the lead counsel is Mr. Amit Kumar, Lordship, as one of the respondents. We're also there, Lordship.
You're appearing for whom?
Respondent number 5, Lordship.
Who's respondent number 5?
He's one of the candidates, Lordship.
What's
Mr. Ronnie Lindor.
Ronnie V. Lindor, yes.
You are you're questioning maintainability of the writ petition?
Lordship.
What are the issues have you raised? Yes, Mr. Karam. You're appearing for number 5?
Lordship.
Who's appearing for the speaker?
The Mr.
AG.
Where's he? He's not appearing.
He's on legs, if I'm not mistaken. There's a division bench. Oh, division bench is over.
Yes.
Lordship, if you may take passport, but I think the AG is having trouble with the VC connection, I'm informed.
Let's see the last order. One second. Yes.
Lord, is Lordship that we are seeking Passover. If Passover.
Yes. Are you ready with the matter today?
Yes, sir, I am ready now. But it will take time, you know. This matter is going to take time. I am ready.
Will we take it at the end of the board?
Yes, sir.
Mr. Khurshid Khan is appearing.
No, Mr. Khurshid.
Salman Khurshid.
Yes, sir. He's on his legs.
Salman Khurshid.
Supreme Court. That's why we're seeking a passover.
Yes. If time permits, yes. Because the other fixed matters are there before this for hearing. Yes. For time being.
45.
Please, my lord, sir. I am appearing for the petitioner in item number 45. Lord, sir, on the last occasion, my lord said asked us to take instruction. My lord's recollect. We were requesting for a arbitrator to be appointed from an MES panel. Because I have taken instructions, we are okay with whichever name my lord suggests. We are okay with
Retired judgment.
my lord.
You suggest someone.
Mr. Swipe.
If my lords,
number of cases
we have checked with 2-3 of them, but we did not got a positive response. So therefore, I am leaving it to my lords.
Dr. Agarwal, you suggest some names.
Yes. Justice Agrawal or Justice Swipe. Justice Swipe, I think some cases
3 or 4 already been given. Yes, the parties today submit that they have no objections if the arbitrator is nominated by the court and a retired judge, High Court judge is by the court. And this accordingly, the name of the suggested name of Justice B.D. Agarwal also is accepted by both parties. Stop registry to seek consent. Justice B.D. Agarwal to be the sole arbitrator. Just after receipt of consent, yes.
I'm deeply obliged, Lord.
46.
Past restrictions. It was on 10th August.
It's on 10th.
On 10th August, she was called for medical file.
Then what happened after that?
That has not come in. That has not come.
It goes to contempt. Anyway, we'll see after 2 weeks to wait to allow the learner DSJ to receive instructions. Yes.
47.
Just yesterday, my lord, I received a copy of the affidavit. I may be allowed to file a rejoinder.
Rejoinder and contempt?
Rejoinder, my lord, yes. We have not even examined that matter yet. The affidavit.
Sami Ahmed submits that copy of the affidavit filed by the respondents just to receive based on 1 week's time to examine this. Yes. Yes, thereafter.
48.
So we have received notice for the respondent's lordship.
It's a contempt matter, my lord.
Oh. Sole respondent?
There are two respondents.
You are appearing both of them?
Both of them.
Mr. Anand enter appearance on behalf of both the respondents. Such notice complete. He prays for allowed 2 weeks time to file affidavit.
So we instructed them to comply to the.
But there's a direction to pay.
Yes, to file affidavit. To pay.
My lord,
How
to
much?
pay around 2,80,000, my lord.
I've instructed them to do it.
Pay. He also further submits that instructions are already been given to the respondents to comply with the orders of this court.
The mediation agreement.
As per the mediation agreement.
Oh, to comply as per the mediation agreement. Just after 2 weeks. It's like score out the affidavit. The appearance notice complete. Mr. Anand submits that instructions have been given to respondents to comply with the order arrived at the mediation.
49.
Yes.
Forty-nine.
It's fixed
Who
for
W
rejoinder,
Rumbai?
your lordship. Mr. J. Thaba is appearing.
No, last time who W Rumbai? None appears on behalf of the petitioner just after 3 weeks. Yes.
50.
Promotion matter.
I'm praying for some more time, lordship.
How many times you saw Dr. Muzika?
Taken 3-4 times.
Twice.
No, 3-4 times.
Twice.
Okay, we'll give further 2 weeks.
Twice. 2026 matter.
Only 2 weeks time.
Look, I think same would be the case for items 54 and 57. My lord.
57 same order. For 2 weeks time allowed.
54 and 57. My lord.
Yes.
Apply.
51.
May I please, your lordship, I'm appearing on behalf of the petitioner.
Yes.
The matter is basically, we basically need the reply of respondent number 2 as they have not taken any steps. So I know that the respondent number 3 has not received any, he has not been served, but at least the parties who have received the copies of the
What kind of submission is that? Last time MSP Agarwal, where is she? You are project. Last time you sought time to obtain correct address number 4.
Correct.
Now you're seeking replies.
We have already given a reply, Your Lordship. Respondent number 2 has a warning to our file.
Given reply. Where's that?
The affidavit is on record.
We have received another address, but that is also similar. We have not received another address.
Then MS Prigati P. Agarwala submits that they have not been able to obtain the fresh address of number 4. Such steps have been taken. Stop. MST Yangi be appearing for the
1 and 2, Your Lordship.
1 and 2
State.
submits affidavit since been
Yes.
filed. Since been filed. We have not received the affidavit.
No, as per my knowledge, we haven't received it.
Kindly
We
take
will file an
instructions.
rejoinder.
Yes.
We can't file it.
Yes, sir. Also, rejoinder may be filed within 2 weeks if necessary. Yes. You 3.
3 is also.
You file affidavit.
No relief has been sought against me.
52.
Ms. N. Contempt 3 submits that a true relief is sought against the respondent. No affidavit is forthcoming. Yes. MSGCH Marak.
Respondent number.
Affidavits.
Yes, my affidavit is ready, Your Lordship. I'll be
Ready?
filing it.
1 and 3. 1 to 3 is
4,
5.
5, 6. Yes.
Yeah, 1 to 3.
For 4, 5, 6, Your Lordship.
Your private is a Nokma matter.
Yes, Lordship.
You are the private respondent.
Yes, Lordship. Yes, Lordship.
When you will file it?
I'll receive it today and I'll file it. Your Lordship.
Today?
Yes.
Very good. Miss affidavit has since been filed on behalf of 1 and 3. What is your name?
Pihing. I'm appearing
You
on
have got
behalf
the
of
name Pihing, Mr. SD. MS Pihing also submits affidavit since been filed on behalf of 1, 2 and 3. Mr. Next parameter Jit Puchang submits that the affidavit have 4, 5 and 6 will be filed within 2 days.
Yes, sir.
Very good. Just thereafter,
2
after
weeks,
how
2
long?
weeks, Lordship.
For rejoinder of any?
Yes, Lordship. High Court, Lordship.
53.
This is for affidavits, Lordship.
I'm going for some more time.
Yes. This is 3 weeks for the time as per yet allowed. Affidavit.
55.
Lord, this petition has rendered infructuous if the Lordship would require.
Lordship, I may be allowed to do the liberty to take appropriate remedies as per law, Lordship.
Yes, Mr. S.E. Sheikh submitted on instructions that he may be allowed to withdraw this petition. Will deputy to file a fresh issue advice? To file a fresh of according submission of the Senate Council.
No remedy with the liberty to approach appropriate.
Yes, goes with deputy to file a fresh or to take any other steps necessary.
Yes.
Yes.
According with law. In accordance with law,
Lordship.
In accordance with law, yes.
56.
Please, Lordship. We have filed a service affidavit.
So you had a long holiday, you're not around for a long time?
I'm just practicing independently, my Lord.
What happened?
I'm practicing independently now.
Very good. Yeah.
We have filed a service affidavit, my Lord, to the respondents 3 and 4, delivered since June, my Lord.
Yes.
This is State Bank, Joy and Cyber Cell at Ahmedabad.
Mr. S. And after being a record, the factum of service on respondents 3 and 4 has since been filed. As such, notice complete on all the respondents. However, there is no appearance on behalf of the said respondent 3 and 4. MSZ in is present on behalf of respondents
1 and 2, Your Lordship.
You'll file affidavit.
No, Your Lordship.
Is present on behalf of 1 and 2 and submits that no after report coming from these respondents stuff. Just after 2 weeks for appearance of response 3 and 4. Yes.
Obliged, Your Lordship.
58.
58. Your
58.
My
matter is very.
Your Lordship, I'm praying for some time to file an
2 days gone because the person has lost the service job only because of
what she was challenging the authority,
challenging the termination order.
temporary appointment, Your Lordship.
But anyway, there is an allegation against her.
Allegation against her?
Yes, yes.
So you feel that once allegation is there, it
should not a simpliciter.
Should be proper dispute
Proper
proceedings.
dispute is there. But affidavit, if they file, is better.
Yes, MSZ inquiry plays further.
2 weeks time, Your Lordship.
And affidavit, yes, yes, thereafter.
59.
Your Lordship, I'm making a similar prayer here. We're awaiting instructions.
What's the matter about? You're for the petitioner. Who's Mr. S. Hussain?
petition.
Yes, MSZ is going to raise will out further 1 week's time for instructions.
2 weeks, Your Lordship.
What's the matter about? School?
No, Your Lordship.
Your Lordship, it's for the application of the 2017 revised pay structure of repetition.
Is this after 2 weeks under pre-absence of the week for instructions or affidavit? Yes.
Obliged, Your Lordship.
Yeah.
60.
Yes.
Yes, Your Lordship. This matter is pertaining to freezing of an account. We have taken steps.
Yes, who's appearing on behalf of the other respondents?
Lordship, we are appearing on behalf of respondent number 2.
Why are you appearing personally?
We have not appointed a lawyer yet.
You appoint a lawyer. We never ask for a personal appearance.
Okay, sir.
We listed after 1 week. You appoint a lawyer. Yes.
Okay.
What is your name?
Akshansh Dubey, Your Lordship.
You're the branch manager.
Law officer.
Law. The respondent number 2. Today is represented by the law officer who's praised that we without 1 week's time to appoint an advocate. Stop. On behalf of respondent number 2 and 4. Yes, MSEDC is present. What about number 1?
We have taken steps, Your Lord.
Regarding number 1, Mr. Estapa submitted steps have been taken, but service reports awaited. Just after 1 week, further orders, yes.
Okay. Thank you, Lordship.
You should engage lawyer, you cannot appear personally and it's called for.
Sure, Lordship.
Obliged.
61.
Please, Your Lordship.
Yes.
Your Lordship, pursuant to order dated 31/7/2026, we have issued notice to respondents 4 and 5, and the affidavit of service has also been filed.
Yes. You appear 4 and 5? Yes. What do you want today? You file affidavit.
Lordship, so far as state is concerned, Lordship would like to file some instruction on to bring on record some instruction, Your Lordship, regarding the action taken by the Deputy Commissioner as well as by the police, Your Lordship. Would like to bring on
What action have you taken?
Lordship, because there is allegation, Your Lordship, that nothing has been done by this Deputy Commissioner as well as by the police, Your Lordship.
What's the matter about?
That is the Lordship, that Shillong Club regarding the repair.
Oh, that
Lordship.
Renovation work, Lordship.
Okay. Yes. What do you want to file instructions by affidavit or just place instructions?
Just to file on record, to bring on record the action taken report, Your Lordship.
Mr. J. Suchang has that appearance today on behalf of the respondents number 4 and 5. As such, notice complete all the respondents. Stop. Next paragraph. Ms. Ndishwarai Leonard EEG on behalf with MS Ailingwa on behalf of respondent 1, 2 and 3.
Lordship, yes.
Praise that he allowed to place instructions received by your affidavit.
Lordship.
On this stop. Mr. J. Suchang also has similar prayer for affidavit by respondent 4 and 5.
After 2 weeks.
Just after 2 weeks.
Lordship of the interim relief.
Order, I need to continue. Yes.
Second call, supplementary 1.
Yes. What is this?
May it please Your Lordship. Lordship, the petitioner herein is before Your Lordship as he is aggrieved by the arbitrary actions of the respondents, which culminated in the impugned order dated 2707.
Synopsis once again.
Yes, Lordship.
Sora.
Yes, Lordship.
Yes.
Yes, Lordship. The petitioner is aggrieved by the arbitrary actions of the respondents, which culminated in the impugned order dated 2707/2026, which is at page number 85, Lordship, Annexure 13. This is an order directing the acting chief to prepare an electors list. 85, Lordship, annexure number 13. Basically,
have you
the last page of the writ petition, Lordship.
'85?
Yes, Lordship.
Yes.
The translated copy is at page number 86. Now, this is an order directing the acting chief, Sora CMship, to prepare an electors list for in preparation for the election of the CM.
Yes.
Now, what is clear from this order, Lordship, is if we see at the bottom of the page, the signing officer is the returning officer, which shows a clear intent that an election is to be held. Now, Lordship, the reason for the petitioner approaching this honourable court is not only because he is aggrieved alone, but the general populace is also aggrieved. The Khon ki Hajar are also aggrieved by this instant order. Now, Lordship, in order for me to better take your Lordship through the series of events which led to the culmination of this instant order, Lordship, the history of Sora CMship dictates that in order for a CM to be recognized as a CM of Hima Sora, he has to pass through a particular rite of passage, which is the cremation of the deceased CM.
Yeah.
Lordship, there are two important aspects to the succession of the CMship. That is the appointment of the CM and the rite of passage. Now, Lordship, the Act of 1959 prescribes the manner and mode of the election. However, the power of appointment lies with the general populace. That is the Dorbar Hima. Now, the second aspect, Lordship, is the
Act says what? It doesn't say as per custom, correct?
It says as per customs,
So we have to
Lordship.
establish the custom.
Yes, Lordship. That's why, Lordship, the power of appointment of the CM of Hima Sora is as per the prevailing customs, which is done by the Dorbar Hima. So what had happened, Lordship, is that on the 31st of October 2025, the then CM passed away, and soon after, notifications and representations were sent to all over the state, to all the various stakeholders, apprising of the death. Then on the 1st of November 2025, an executive Dorbar was convened to discuss many things, Lordship, and one of them is to discuss the funeral or the last rites of the deceased CM. Then, Lordship, by the Dorbar Hima was also in receipt of a representation from the ruling clan, which is the CM Sora clan, by a representation dated 1/11/2025, which states that they have proposed the name of the deputy CM to be the successor of the deceased CM. Now, this same representation was placed before the Dorbar Hima, which was convened on 3/11/2025. The Dorbar Hima unanimously approved the name and elected the...
Where is that? It's here?
Yes, Lordship, it has been annexed here. The minutes of the meeting is at page number 47, Lordship, annexure 6. Page 47, annexure 6, and the translated copy is at page number 51. Let me read, Lordship. The Dorbar Hima Sora, comprising the Sardars, Rangbashnongs, headmen, and the elders of Hima Sora, was held on 3rd November 2025 at the Dorbar Hall of Hima Sora and adopted the following resolutions. The meeting was opened and conducted by Maram Dwar CM, who was the Deputy Chief of Hima Sora. Before the commencement of the Dorbar, a moment of silence was observed as a mark of sorrow for the demise of the CM Rangba. After the momentary silence, the chairman addressed the gatherings and welcomed all the Sardars, Rangbashnongs, headmen, secretaries of Raj and Shnongs, and the elders of Hima Sora who had taken the time and made the effort to attend the Dorbar. The chairman requested all members of the Dorbar who wished to participate in the deliberations to speak one after another and not to interrupt or speak over one another. After lengthy and careful deliberations, the Dorbar Hima adopted the following resolutions. The Dorbar as a whole expressed its strong desire and earnest wish to revive the traditional rites and customs of the Thang CM of Hima Sora, which has not been witnessed for more than 99 years. Accordingly, the Darbar resolved that as a mark of honor, the mortal remains of Shri so-and-so shall be cremated through the Thang Ling Khason by performing the traditional rites and ceremonies of Thang Yap in accordance with the customary practices and traditions that have existed. In order to cremate the deceased chief through the Ling Khason, it is necessary that the ceremony be performed by a chief who succeeds and takes the place of the deceased chief. Therefore, the Darbar resolved that the chief must first be appointed, and that if a chief is not appointed, the Ling Khason ceremony cannot be performed for the mortal remains of the deceased chief. In connection with the appointment of the chief in replacement of the Darbar Hima, the Darbar Hima also received the resolution proceedings of the Executive Darbar Sora, a Darbar comprising the Mintris and the elders of Hima Sora. The Executive Darbar had unanimously resolved to approve the name of Maramdor Siem, Deputy Chief, to become the succeeding chief in place of the late Freeman Siem. The Darbar Hima, having considered that the Siem Sora clan, together with the Darbar of the Mintris and elders of Hima Sora, had approved and proposed the name of Maramdor Siem, Deputy Chief, to become the succeeding chief in place of the late Freeman Siem, accordingly the Darbar held on 3rd November 2025 unanimously resolved to appoint and confirm Maramdor Siem as the full chief to succeed the late Freeman Singh Siem.
Okay, yes, I've seen this one.
Yes, Lordship. Now, if I may take Lordship to the representation sent by the ruling clan, which is at page number 36, Lordship, annexure 4. The typed copy is at 37 and the translated copy is at page number 38. Page number 38, Lordship.
Yeah.
To the if I may read, Lordship, to the Mintri and Bakrao Hima Sora, Sora Siemship, subject, nomination of the chief from the chief's lineage within Hima Sora. We, the undersigned, who are the children of the late Yar Timai Siem, wish to bring to your authorities notice that with one united voice, we have designated Maramdor Siem, the deputy chief of Hima Sora, whom we appointed in the year 2016 as the deputy chief, and now, following the passing of our uncle, late so-and-so, on 31st October 2025, Maramdor Siem will assume as chief of Hima Sora. At the same time, we inform you that no one can put a complaint to this agreement and decision made by us, because we are the only children and grandchildren left of late so-and-so, who are the rightful heirs to become chief in Hima Sora according to customs and religious traditions. So, Lordship, based on these...
So you say this is a custom established?
Yes, Lordship.
Once there's a recommendation from the CM, course CM.
Yes, Lordship.
Then it goes to Darbar Hima.
It goes to the Executive Darbar, Lordship. So what happened, Lordship, after what has been followed in the previous years, Lordship, is that on the death of a CM, the Executive Darbar approaches the ruling clan to take out a name, to propose a name, and if that name is singular and unopposed, that same name is brought forward before the Darbar Hima, and if in the opinion of the Darbar Hima it sees fit to elevate him to the CMship, then that...
So if suppose there's any other contestant, is it possible?
If there's any other contestant, then an election should be held, Lordship. Okay. That's what happens. Yeah. But in this matter, Lordship, in this instant case, there was no other opposition from any other quarters.
Yes. Then what happened after that?
So, Lordship, after that, after the cremation ceremony was held on the 5th of November 2025, the first set of representations was sent to the respondent authorities, asking for the issuance of the sanat to the elected CM, who was elected by a free and democratically recognized process. The first series of
when did you first send representation?
Yes, Lordship, I have that with me. It is at page number... It is at page number 73, Lordship. It is at annexure 9, 4th of November 2025. The translated copy is at page number 73. If I may read, Lordship.
No, it's okay. This is, you've informed them. That is
yes,
one.
Lordship. At every step of the way, after the demise, since the demise...
When was Darbar? When was your name approved by the Executive Darbar?
By the Executive Darbar on the 1st of November, 1st 11 2025.
Okay.
Then the name was approved by the Darbar Hima on the 3rd on the 3rd of November 2025, and the funeral was held on the 5th of November 2025.
Yes.
The first representation sent to the district council.
4th December.
Yes, Lordship, was on the 4th of December.
Just page 73.
Yes, Lordship, page number 73.
Okay. Then what happened after that?
After that, Lordship, the respondent authorities asked for records to be placed before it, the minutes of the meetings, the approval from the clan, which the HIMA had done so in compliance with such a request, and it was sent by representation dated number 13, dated 13th January. Apologies, Lordship. This is
the second representation, 13 January.
Yes, Lordship. That is the last representation. Apologies, Lordship. I have
10/01/26. This is letter confirming.
the first representation was on 10th November, Lordship, 2025.
Where is that?
That is at page number 54. Page number 54, and the type.
First representation is on 10 November.
10th November, yes, Lordship.
Second is 4/12.
No, Lordship. The second is on the 12th November, which is at page number 61.
No, first one's on 10th.
Yes, Lordship. The first one is on the 10th of November. The second one is at page number 61. Placing before it the records.
1 second. Next representation was
on the 12th of November.
12, 2 days after that.
Yes, Lordship.
Yes.
Placing on records the various documents.
Then third was on.
And the third was on the 4th. Yes, Lordship. 4th December.
So what reply did they give?
Lordship, there was no reply from their end.
Till now?
Yes, Lordship, till now. And the last representation was on the 13th of January 2026, which was sent by the Mintries and the Bakraus of the HIMA.
Okay, yes.
So what had happened, Lordship, is that there was a lot of back and forth verbally, and they said that, and the respondent authority said that they will look into the matter. However, nothing came out of it. Angered by the silence, the Kikhongi Hajar of HIMA Sara resorted to stage a march to the office of the district council. And it was then that it was revealed that the respondent authorities will not be issuing a sanat to the petitioner.
Okay. And they issued impugned order calling for electors. Why?
Yes, Lordship. The impugned order 2707/2026.
Yes. Yes, Mr. Chariso.
My Lord, in this case, squarely fall under Section 3 and 4 of the 1959 Act. My Lord, may I kindly see the Act? The procedure is detailedly laid down there. It appears that before this provision is put into place for implementation, they have taken all the steps. My Lord, 1959 Act.
59 Act, it doesn't cover Swaraj. It's a general act.
It's a general act, Lordship, and it only prescribes the mode and the manner of the appointment, not the power of the appointment.
Can say the section, my Lord.
1 second.
Yes. The compilation, my Lord. Page number 7 in the second section. Page number 7, the second volume.
No,
second volume.
Yes, I can put it.
Second volume. Page number 7, my Lord. Page number 7.
Yes. What do you say?
And my Lord, can see sections 3 and 4. It is very clear.
Yeah.
May just read it out with Lordship permission. Election, nomination, appointment of the chief and headman. Subject to the provisions of this Act and the rules made herein under, all elections or nominations and appointment of chiefs and headmen shall be in accordance with existing custom or prevailing in the Ilega concerned, and or in accordance with the order as the Executive Committee may issue from time to time. The Secretary of the Executive Committee or any officer appointed by the Executive Committee in this behalf shall be the returning officer for all the nomination election under this section. Section 4, my Lord. When a vacancy occurs, the returning officer shall cause a meeting of the Electoral College of the Ilaka concerned to be held and presided over by the officer deputed by the returning officer. The presiding officer shall submit the proceedings of the nomination meeting to the returning officer, who shall declare the result of the nomination. The returning officer may, in the cases of doubt or uncertainty, refer the proceedings to the executive committee, who shall decide and direct the returning officer accordingly. When vacancy occur in an Ilaka where there is no electoral college, the returning officer shall cause the electoral roll to be prepared of all eligible voters called for the nomination of candidates, hold election, declare the result thereof, and or do things necessary for the purpose of election. The returning officer may refer cases of doubt or uncertainty to the executive committee, who shall decide and direct the returning officer accordingly. And this 5 is the appointment process. Now, admittedly here, it is not the case of the petitioner that there is an electoral college. Even if there is an electoral college, my lord, district council has to initiate the election nomination process. Appoint
so
the
one thing, Mr. Chandeso.
Well,
see, Section 3.
Yes.
It was amended later on, correct?
Yes.
If I remember correctly. In the reason. Now it says subject to this act and rules made that under all elections shall be in accordance with existing custom prevailing in the Ilaka. Now what case I'm making, if I understand correctly, the prevailing custom has been followed by them.
Yes, Lordship.
So with that, they have made a representation before before you that since prevailing custom has been followed, and there's only one person who's been nominated to be the same. So what are you going to do about that? You have not answered that also.
Even those representations have also not been.
Before they do that, my lord, council has to follow the Section 4, appointing a returning officer.
They've given you 5 representations. Why don't you see fit to reply to the representation?
There is no formal reply. We have appointed acting chief.
Acting chief is fine. Acting chief can be A, B, C, D, E, F, G, doesn't matter.
But they have to follow.
See, the thing is that now the act, the core issue or the core basis on all these traditions is that what is the custom prevailing in the Ilaka, right?
Yes.
Number 2, what is the method of election?
Yes.
Number 3 is whether the electoral college is confined or whether it's a public election. Those things are to be examined by the district council.
Yes.
Now, if suppose there's a prayer on behalf, because they said that lots of people are aggrieved, right? Now they've come with representations saying that this has happened. These certain things have happened which comply with the existing customs. Kindly issue some. Now, don't you think you should have at least?
I
understand where
I fairly consider that they could have issue notice to them, or give a reply, formal reply.
You have to answer that.
Mode.
Why? Suppose they agree with the order. Why they asking electors this? Now, where that come from? Now, without any, there has to be some justification given to them also. Why we doing this? Why we want electoral college?
But I would take the instruction whether the council has given the opportunity to establish the mode of election in this process, my lord.
That's your duty to advise them also, because you can't just out of the blue. Suppose you put yourself in their position. Suppose they say, okay, we find you've done all this, and you just don't consider representative also, and one fine day you give something else.
Well, that is true. And in other side of the coin, my lord, we cannot just simply accept whatever they ask.
You cannot, but then you're a constitutional authority.
They have to do their due diligence.
So you have to have responsibility. To satisfy, because you have to regulate traditional institutions.
Right.
That is the constitutional duty given on you.
I'll take
that is the thing.
I'll take that is the crux of the matter, the procedure, fair procedure, my lord.
Yes.
We come up next week, my lord, after 10 days. I'll take instruction, my lord.
Yes, sir.
I'm also praying for an interim stay, Lordship, of the impugned order, that it should not be given effect to.
Well, let them come instructions. Yes, we will keep.
We will not take action. Yes, or no.
Yes. No harm be done, because the process not started. Yes, sir.
Not yet started.
Yes, sir. But Mr. LCM, Learned Counsel for the petitioner, issue notice. Mr. Chandraso, you are appearing for all?
For all, my lord.
Yes, Mr. H.
1 to 3. I'm sorry.
1 to 3. Mr. H. Chandraso is in the council with Mr. Tidahar.
Yes, Tidahar.
If are present on behalf of the respondents, sooner for the notice required. Stop. The issue in question, as per the Learned Counsel for the petitioner, is the non-grant of the sanad to the petitioner, who he submits has been proposed and nominated as per existing custom to be the chief strokes EM of Himasora. The Learned Council has drawn the attention of this court to the various events that have taken place after the death of the last permanence EM on
the 31st of October 2025,
wherein the darbars were held and the petitioner was unanimously proposed to be the new chief
successor.
He submits that, however, in spite of repeated representations from 10th of November onwards,
10th of November, Lordship.
yes, till the 30th of January 2026, no reply has been received from the respondents. But however, instead the impugn order has been issued, calling for preparation of electoral roll by a nominated returning officer and staff. He therefore prays that as the representation has not been answered as to the manner, as to the reason for issuance of the impugn order, he prays that the same be kept in abeyance for the time being. Yes. Next parameter, HL Changri Solution Council, which is the CAR, has submitted that the process for nomination and appointment of chief is as given in the Appointment of Chief Successions Act 1959 has provided section 3 and 4 the procedure and the manner in which the elections elections are to be conducted and gone about. He fairly submits, however, that he is yet to receive instructions with regard to whether the representations of the petitioner was addressed by the respondent before issuance of the impugn letter calling for the preparation of the draft electoral roll. Next paragraph. This court has, on hearing the counsels for the parties and also on perusal of the materials available, it appears that the matter has been at a stalemate due to the non disposal of the representations of the writ petitioner and others.
Lordship.
Yes, who have prayed before the municipal authorities for appropriate action of issuance of sanad. As the Learned Senior Council has sought time to obtain proper instructions, it is provided that the next date the impugn notification letter shall not be given effect to. Yes, just after 2 weeks.
2 weeks.
Hearing, Supplement 5.
Mr. Rubin,
yes, madam.
To make the issue small, I mean to short.
Yes.
Now, basically, you were in contention in one selection process. It's called selection process number 1, correct? Where you did not succeed. Then there was a second selection process.
Yes.
Impugning that.
Yes, my lord.
That's the short of it. Right?
That's the short, my lord. Why? Because, my lord, before I forward my submissions, my lord, I like to draw my lord's attention to the NEPCO recruitment rules. So also the NEPCO revised recruitment rules.
You are agree with the relaxation?
I am agree with the realization. Why? Because, my lord, they have changed the the relaxations, my lord, in order to.
One second. Not teasing, water teasing.
I thought, my lord, something else.
No.
Because my lord's expressions.
Water here. It's very bad. Anyway.
My lord. So, my lord, my contention was, my lord, in the expressly existing panel, my lord, they have changed. They have brought out with another advertisement for the vacancy of the same post, my lord, of the same post of the same category, my lord, thereby changing the category and also the relaxation. Now, what happened?
What do you mean by changing the category?
Category, my lord, now what they have done is they are saying the roster, my lord. They're saying that it is for the SC and OBC. In the subsistence of the panel, they are saying in by operation of roster, we are changed. So now the category has changed, and the people from that category does not have the eligibility criteria of experience. Therefore, they have relaxed to 5 years, my lord. So what has, by doing so, my lord, the ST and panel candidates have been totally rendered ineligible. So that is where my concern is. So therefore, my lord, I like to show, and roster also, my lord, I will come and answer, my lord, because probably that is the only point they have of doing so, my lord. First, my lord, yes, my lord, I'll show the recruitment rules first, my lord.
Yes, 1 second.
I don't have now. You should have filed it with the reputation.
No, this is your, sir, your
No,
recruitment
mine,
rules only.
but it is.
No, I'll share with you the recruitment rules.
No, but you should have been fair to the senior counsel and.
My lord, well,
warning.
My lord, I can show
the
today.
general prepares thoroughly. Kind of giving across the board.
But this is their own recruitment rules. My lord.
No, my own recruitment, but you should draw the attention in the writ petition so that I could what you want to say by that.
Yes. So I'll read out, my lord.
Take out from the pocket and give.
My lord, NAPCO recruitment rules. My lord, first I'll take my lord's attention to 7.1. 7.1 sub rule 2, my lord. Sub rule 2 is what it says, my lord. My lord has got it.
Yes, 1 second. Yes. So sub rule 2.
2, my lord. In a Roman 2, my lord. It says that because this one 7.1 will say direct recruitment from outside, and clause 2, the Roman 2, it says, my lord, when direct recruitment is resorted to,
Just come again. Sorry.
So basically,
Direct route outside.
yes,
7.1.
7.1,
Yes.
and my lord will see Roman 2, the sub rule 2.
Yes.
Yes.
When direct one is resorted to.
Yes, yes. Existing employees of the corporation may also apply against advertisements. Provided they fulfill the prescribed requirements, relaxation in the qualification / experience of internal candidate may be considered by appointing authority. So this also applies to the internal candidates, my lord. Now, my lord will see 4, the Roman 4, sub rule 4, my lord. The selection committee will arrange the names of the selected candidates in order of merit, and the appointing authority will make appointments in that order unless for any special reasons to be recorded it is found necessary to vary that order in any particular case. Panel of selected candidates kept in reserve, which normally shall not exceed 50% of the number of advertised vacancies, will remain alive for a period of 1 year.
So your case hinges around this.
Yes, 1 year. Well, I'll just.
Okay, one thing just
Yes.
to now the selection. First selection was held second was within 1 year.
Within 6 months. 1 year is very far. 6 months, my lord. 6 months. Now, my lord, I will draw to their NAPCO revised recruitment rules also, my lord. Of course, that is not applicable to me, but this is in. My lord will have my rejoinder affidavit, my lord. My rejoinder affidavit.
This is as on 31/8/23.
Yes, my lord.
This is. Okay.
So now, my lord, I will show the rejoinder. Kindly look at my I have my rejoinder affidavit, my lord. Rejoinder affidavit. Yes, my lord. My rejoinder affidavit. I'll take my lord straight to page 16. Page 16. My lord has got page 16. My lord,
Not as quick as you.
Yes, my lord. This is the NEPCO revised requirement rules of 2025 and 19.0, my lord.
What is dated when?
This.
25.
Yes, my lord. 2025, my lord.
Okay.
So, 19.0.
Okay.
Operation of panel of selected candidates, my lord. 19.1. The panel of candidates in order of merit as recommended by the selection committee on approval by the appointing authority will form the basis for issue of offers of appointment. 19.2, my lord. The functional panel of selected candidates will normally remain valid and operative for a period of 12 months. And from the date of approval and on expiry of this period, it will cease to operate unless decided otherwise by the appointing authority for reasons to be recorded in writing. Now, 19.3, my lord. Based on the panel as recommended by the selection committee, HR department will issue offers of appointment to one or more candidates in the order of merit given in a panel depending on the number of posts as sanctioned by the appointing authority from time to time. So the selection has to be done, the appointment has to be done.
Okay, 19.1.
Yes.
The panel of candidates in order of merit
as recommended by the selection
would form the basis for issue of appointment.
Yes, my lord.
So merit list is maintained.
Now I'll
as
take
per your submission.
Yes,
then
my lord.
The functional panel of selected candidates. What do you mean functional panel?
The functional panel, my lord, that is the merit list itself, my lord, because the other word
will normally remain valid.
Yes.
Will normally mean it's already the rider.
Yes. Normally remain
valid in operative period of 12 months from the date.
12 months.
That means earlier on it was like mandated 12 months.
Yes.
Now by this revised 19.2, it says that I'm just trying to understand.
Yes.
Well, normally remain valid after a period of 12 months from the day of approval.
Yes.
And on expiry period, you'll cease to operate. Okay, fine.
Yes.
The 19.3.
Yes.
Based on the panel's recommended results, will issue offers point to one of candidates or the merit depending on number of posts. Okay.
Yes. Okay. So now.
But you mean to have the recorded reasons and writing for not adhering to 12 months?
Yes. So
you're given.
I'm sorry, my lord.
Now they had a second selection.
Yes.
As per submission within 6 months, correct?
Yes, correct.
Now, in doing that, have they adhered to 19.2 in giving reasons as to why
no, absolutely
panel will not be maintained?
No, absolutely silent. Now, my lord, I will take my lord to page 7 of the affidavit in opposition, because now we'll have to see empanelment, because that is what they are saying, that we have not empaneled you. So, page affidavit in opposition. This is affidavit. My lord, page 7 of the affidavit in opposition. My lord has got page 7 of the affidavit in opposition.
Yes.
I will read, my lord, paragraph 8, page 7, 6, my lord, Roman 6. Roman 6, my lord. May I read, my lord?
Paragraph 8.
That's paragraph, page 7. Roman 6, my lord, that point.
Okay.
On the prima facie from there, my lord. On the prima facie administrative scrutiny of the documents submitted by the candidates, it was found that only 3 candidates are eligible for 1 UR vacancies. The administrative scrutiny has been done purely as per the circular dated so and so and the relevant rules and force at the relevant time. As decided by the competent authority, all the eligible candidates were called for offline personal interview for the post of executive trainee, which was conducted on 03/06/2025 at Corporate Office, Shillong. A selection committee was constituted by the competent authority for the offline personal interview who were present on the date of interview on 03/06/20. All 3 candidates attended the offline. Now, next point, Mala. The selection committee, after having assessed the suitability of the candidate based on the performance during the interview, recommended the following candidates in order of merit to be appointed as executive training against 1 UR vacancies, which was approved by the competent authority of the respondent corporation, my lord. Now, these are the recommended candidates in order of merit.
This is when was it held selection?
My lord, this is the first selection where I said where I was empaneled, my lord, which they dispute. And now in their own affidavit, they are saying that on the point of merit, these people were recommended by the selection committee, my lord.
Yes.
So this is, so then now paragraph 8, my lord. As per the, yes, as per the recommendation of selection committee, the merit list prepared by the selection committee, an offer of appointment to the post of executive training was made to Tage Tachang, who was placed at serial number 1, and the same was accepted by him and joined the post. The merit list so prepared after joining of Tachang came to an end, and there was no such empanelment prepared for appointment for the 6 months as it was alleged. The statement of petitioner para so is devoid of merit. So now, my lord, what they are saying is, now this is something which are going against their own rules.
Now are they trying to make a case that there's only one post of ST?
No, not like that. Not that. Because the post that we have applied is an unreserved. Anyone in the internal candidates, anyone who is eligible of 15 years of experience, we're eligible to apply, unreserved. Is it be ST, SC, OBC, anybody can apply. So now, my lord, now my contention is, my lord, now you already have a vacancy. And how do I prove that you already have a vacancy? My lord will see the first advertisement at page 18 of my writ petition. Page 18 of my writ petition. 1.8, my lord has got that.
Yes.
So, my lord, down there it says that executive training electrical, total number of vacancies, my lord, so and so, there's just 13 posts. That is 13 posts is an...
Where are you reading from?
My lord, bottom, at the bottom, my lord. That in the column, my lord has got a column.
Executive training firm. Where's the number given?
18. Oh, this is annexure 1 of my writ petition.
Where you get the number of 18?
13. I'm sorry.
Where?
The bottom, my lord. I'm just
qualification.
No, my lord. This annexure 18 of my writ petition, my lord. 18. 18.
Oh, and like what page is it?
This is page 18 of annexure 1 of my writ petition.
It is 17.
That is page 17 here, I think. Total 13, that's in page 17.
Annexure 1, my lord.
Yes, annexure 1 what not corresponding to?
Yes, my lord.
Petition to the court copy.
So my lord, his got total number of seats is 13.
Right.
13. So the 10% of this 13 is 1.
0.3.
Yes. Yes. Now, my lord, second advertisement, my lord, I'll just take my lord to my rejoinder affidavit again, my lord. Just bear with me because I'll have to show my lord. My rejoinder affidavit at page 40, my lord. Page 40 of my rejoinder affidavit.
1-4.
Four zero. My lord has got page 40, and this advertisement, can you look at?
Yes.
40, my lord has got. Can you look at this? This advertisement of 28/10/2025, and total number of posts is 18.
Yes.
And another advertisement, my lord, at page 48. Page 48, my lord. Page 48, my lord has got.
Yes.
Can you note the date, my lord? 14/5/2026. Total number of posts is 16. So, my lord, within a period of 1 year, all these 3 advertisements have come. So the total number, if you work out, is 47. 47. The 10%. 10% of 47 would be somewhere 4 posts or 5 posts, my lord. So now my lord has seen the merit list.
3 people.
3 people, my lord. 2 people were kept in the reserve, and it is not
18 and 16.
Yes. So it is not a fact that they did not have the vacancies available. They had the vacancies available, so therefore now they cannot take the plea that once that interview, the selected appointment has occurred, finished, then the process have ended there. Because when you already have a vacancies, you cannot end. Of course, I'm not saying that just because I have been empaneled, I have the
indefeasible
right to be appointed. I'm not saying that, my lord. But my lord has to go beyond that. Now what is that, my lord? The question will come, my lord, that which the respondents would have to answer, my lord.
See, one thing, Mr. Yubin, you have to keep in mind that the action taken by them,
yes,
and the prayer made by you, you have to balance it with the advertisements and the rules.
Right.
Now, whether these rules have been followed by the recruitments, have been followed by the respondents.
Yes.
Okay, fine. The first selection was done on whatever date. Then
Yes.
you were empaneled the number 3.
Right.
Now you brought a second advertisement.
Yes.
A third one also.
Yes, my lord.
Yes. So whether as per the rules their actions are legal,
no,
justifiable,
and
whether their action is in violation of the guidelines or rules which they should follow.
Right.
That's the only thing.
Yes, my lord.
Yes.
So
and in that also how you fit your case.
Right.
That the lack of you not being considered has violated the rules also, and they should be applied.
Right.
That's
right.
correct.
Now, so now, my lord, they'll have to answer to that question, my lord.
Yes.
Because my contention is, my lord, when the vacancies is available, I've just shown, my lord, vacancies was there, my lord, and for the same post, but they have altered the category and also the eligibility. First of all, they altered the category. Secondly, they have altered the eligibility in such a manner that already already leave me out. So therefore, my lord, what my contention is, my lord, the petitioners have. I'm not saying that, as I've said, that I don't have an indefeasible right to be, but the petitioners has this much of right the right to fair and non-arbitrary considerations, my lord.
Of course.
Under the governing rules.
That is what they have to show. Governing rules have been violated.
Right.
With regard to first selection, second,
yes,
they've been violated, and they've acted beyond, beyond the mandate of the rules.
Yes.
And also, you have to make out a case that they could not have altered the eligibility criteria.
Right, my lord. So yes. So my lord, this is what? This is like manipulation. They're manipulating with the recruitment mechanism by introducing roster or eligibility conditions, my lord, so as to extinguish the subsisting panel, the rights of the panel. Now, they only what they are saying, my lord, if in the affidavit subsequently, if you read, my lord, they are saying that no, because it's for the roster. Now, I have an answer to that, my lord. If it is
roster meaning the reservation roster.
It is a recruitment roster. Now, even if the roster also, my lord, then they have to show us the roster point. The roster point under which the vacancy.
Have they stated
no,
that?
They have not stated anything. They simply
So
said.
what kind of a story they're following
Yes.
now?
Now, my lord, very interesting is that in the unreserved seat, three ST candidates applied because they were eligible, and one ST candidate got it in an unreserved seat. So the justification is that in this post, ST got, so the next one should be SC or OBC.
No, that the account will not hold.
That is what they're saying. So my point is that, my lord, kindly let them show what is the roster point under which these vacancies were earmarked for SC and ST. And if you talk about roster, my lord, prior to the advertisement of that, my original advertisement where I appeared and was empaneled, that's 2024. They have already advertised for the same post, especially reserved for SC. I can show that one also, my lord. Where is that additional affidavit?
Mr. General, they're going to take a long hearing.
That additional affidavit जहाँ पे हम लोग बताया था previously. But so while my
collated your points, Mr. You've been you've on your points of arguments, I think you've just spelled them out. Have you written them in a note or something like that?
My lord, I have.
To mix it, I mean to...
Yes.
Against the events.
Yes, my lord. I have that, my lord. So, my lord, now, first of all, my lord, you could not have change, because Tej Prakash, my lord, Tej Prakash, this very much says that if you are, even if you are empaneled or married, it doesn't entitle you to be, but the thing is, there's an underlying word, my lord. So, and Tej Prakash at the same time also says that the citations, my lord, at the same time says that, you cannot overrule the recruitment rules by mere contingencies or convenience of your district, because then it will create because it's directly infringing 14 and 16, article 14, 16 again. Yeah, so my lord, they must have a statutory basis on which you relax. I'm not saying that the authority does not have the power to relax in favor of ST or SC or for reservation. I'm not saying that also, my lord. But you must have a statutory basis, and that your reservation, your relaxation must not render already empaneled ST candidate to ineligibility. So that is basically my point, my lord.
No, that's the thing. So see, again coming to that qualifying word, that in the original recruitment rules, it says that 1 year.
Yes, 1 year.
Then in the revised
also this
rule,
yes,
it says normally.
And
reasons that to be given.
Yes. And they have not stated anything. They are and that normally also says that, my lord, if there is the correct wording will be, my lord, it says that normally will remain valid and operative for a period of 12 months from the date of approval, and on the expiry of this period it will cease to operate unless decided otherwise by the appointing authority for reasons to be recorded in writing. So if you are not doing away, if you are doing away, then you have to write a reason. You have to give a justification why this.
To 19.1.
Yes, 19.1, 19.2, my lord. So to that effect, they don't have. Straight away they have advertised, and now they are saying that no. Once the advertisement advertisement was floated, appointment was done, the recruitment process ended there. It doesn't end there in these circumstances, and when your rules is very clear, and even there's a rider for that, if the empanel to end its life also, you must have a reason recorded, and that is nothing there, my lord. So therefore, my lord, the second advertisement.
So you see reason to be recorded for not adhering to rules.
Yes, my lord. So the second advertisement, my lord, by which they have made us ineligible, my lord, this advertisement has no legs to stand, and it must go, my lord. And at the same time, my lord, I'm not saying that give me the job on the basis of merit, my lord. Let it be a fresh, do not change, let be a fair contest in accordance with law. My lord, that is all I have to submit, my lord, and
still it's not very clear. Anyway,
I will reserve my.
You have not made a very compelling argument as yet. You have to show you have to quote. Anyway,
my lord, Tejpal, my lord, is my lord. Now that I would like to point out one of this, my lord, 1998.
You should have given me Visto book. That also you have not given.
I'll give you. I'm so sorry.
I'm taken taken by surprise.
No.
Book.
She is very annoyed with you.
No, my lord. In my almost 15 years of.
So many juniors.
15 years of junior, there's a first occasion where I have an opportunity to fight with sir. So I did not know.
Well, you were under him before?
No, I was.
Started his career.
You are my student.
Oh, that's good. You've seen his kung fu movies. Couldn't fight against master. It's like that.
My lord, this point, my lord, where I want to make my rest.
What is the
Statutory,
citation?
yes, sir, I'll give you this. Statutory rules cannot be overridden but by executive order.
These are under 309, the rules.
Eh?
Even under 309, this recruitment rules under 309. Under Article
No,
309.
309 is not applicable to us.
Not applicable to NIPCO.
No, these are the guide.
But even then, yeah.
These are
My lord, paragraph 2, my lord, this is a very small judgment, my lord. It says, the short point on which these appeals must succeed is that the tribunal fell into an error in taking the view that since the government had indicated its intention to attend the relevant rules, its action in proceeding on the assumption of such an amendment could not be said to be irrational or arbitrary, and therefore the consequential order passed have to be upheld. We are afraid that this line is approach cannot be countenanced. The relevant rules, it is admitted, were framed under the proviso of 309 of the Constitution. They are statutory rules. Statutory rules cannot be overridden by executive orders or executive practices. Merely because the government had taken a decision to amend the rules does not mean that the rules stood obliterated. Till the rule is amended, the rules applies. Even today, the amendment has not been affected as so and so. So the tribunal is therefore wrong in ignoring the rule. So what I'm saying, my lord, the rules is there. The rule is there. Your empanelment provisions are there, my lord. So by executive order, my lord, by your internal decisions, my lord, you cannot change that rule. And more so, my lord, you have to give a speaking order if you want to do so, my lord. So this judgment, my lord, and now another point, my lord, is that K. Manjushri, my lord, if I have to argue on K. Manjushri's case also, my lord.
What is K. Manjushri?
K. Manjushri means, my lord, once the recruitment process has started, you cannot change the rules of the game. Here, because that empanelment would, till the recruitment process in this case would come to an end only after 1 year. So in between, how can you introduce?
No, the one thing which Mr. Jalli have to answer. Now, this selection, the first selection, where there were 3 candidates recommended for selection, that was against UR post only, unreserved seat, unreserved post.
Yes.
And then subsequently you changed saying the ST is already finished, so we will not open the ST anymore as per roster. Is that your case?
I'll answer.
How will you answer that?
No, I'll answer it, Lord.
Then if the UR post is filled up, ST post will be carried over naturally.
No. I'll show.
So
let him finish.
So even if my lord looks at even if that my lord, if you see that your ST post has been reserved, my lord, or SC post has been reserved, and they're talking about roster, my lord. For this particular post, my lord, at no point of time any post was specifically reserved for the ST candidates. In fact, it was reserved for SC candidates. So today they cannot relax. Today they cannot relax to accommodate an SC candidate by saying that by saying that it is a roster. First of all, you have not pointed out what is your roster point for earmarking them. Secondly, my lord, then if that be the case, then let them show, my lord, when have they ever reserved a seat for the ST candidates? They have never, my lord. So therefore, my lord,
you have to see what how they meeting the roster. That's important.
Yes, that's one other. Let them bring the records, my lord. How did they earmark? It's very important. It's not that today I've appointed ST, tomorrow advertisement I'll appoint ST, after that OBC. It does not go in that way. The roster system does not work in that way. The roster system, there has to be a point. There has to be a point. So therefore, my lord, this is very important because the only shelter that they are taking is the roster system.
Have they elaborated in the affidavit?
No, they have not elaborated in their affidavit on opposition.
So how they why they have resorted to this action is in pursuance to the roster system.
Yes, my lord. Can you look at paragraph 9? Paragraph 9 of their affidavit in opposition, my lord. Paragraph, my lord has got paragraph 9. of their affidavit and opposition, page 9.
Yeah.
My lord said that in response with then circular, my lord, we can skip this, my lord, and then come to para 9. Subsequently, my lord has got. Subsequently, a fresh circular dated 23/10/25 was issued to fill up the new vacancies of OBC 1, SC 1 posts in electrical and mechanical cadres as per reservation roster, which also requires 15 years experience. In response to the aforesaid only 2 applicants were received since the post is question was OBC and SC categories. In petitioner were not from the OBC SC category but were from the scheduled tribe, and no candidate belonging to OBC and categories could apply because of the requirement 15 years experience. So except for saying as per reservation roster. So again, my lord, coming back to that point only, my lord, where is the roster point? We know, all of us we know, there is a reservation roster. A roster has to be, because without roster, reservation cannot be effective. It's just a paperwork. So, but where is your roster point? So that is what they have to answer. If they cannot answer, then this advertisement fails, my lord.
Just give 5 minutes, yes.
My lord.
Finish.
Just one more page I would like to point out, my lord. Then, then I'll sum up my submissions, my lord. That's page 46, my lord. Page 46 of my read petition. Of my read petition. Page 46.
Your case many layers. It's not a simple issue. Many layers are there.
My lord.
Because it's the rules, then your roster points.
Yes, my lord.
Then you select your panel.
Yes.
Yes.
So, my lord has got because some page numbers are different, my lord, but there's a circular dated 16 December 2024. My lord has got a circular dated 16 December 2024.
44.
That's 44. It may be 44, my lords, in my lord's page 44.
16 December, yes.
Yes, my lord. So, my lord, what we are talking here is, my lord, kindly look at this. In order to fill up 3 posts, UR2, SC1. Already SC was given 1 here, UR2. And experience also 15 years in NAPCO, my lord. So this is of December 2024 advertisement. The purpose of showing, my lord, is the SC already had the opportunity of reservation prior to that advertisement also, under the advertisement which have appeared. That was UR.
Have you made the pleadings in the writ petition?
Yes, yeah.
No pleading.
Have you made the pleadings regarding the inconsistency with regard to advertisements and where they maintain the roster points and maintain the roster? If you haven't made the submissions, then see what you're saying now.
Yes.
It touches at the core of you how NIPCO maintaining their roster, right?
Right.
Because your selection was against the UR post, ST was given. Now you see ST is not given anymore. Is not it considered any longer out by the second advertisement.
Yes, my lord. So no, because now this is subsequently, my lord, in response to in my petitions, my lord, they have brought up this roster, my lord. So I'm pointing out that if you may have brought a roster. Let's assume that you have correctly brought up the roster.
Now, one thing also that is important for NIPCO, whether they address this issue, how, because we would like to see in which manner, we can interfere. In which manner have you, what do you call it, arrange all these kind of advertisements, eligibility, the roster.
Right.
Yes.
So, my lord, we will have to call for the records, my lord. The office notes, the records, my lord, we'll have to call, because I won't have an occasion to know what is been proceeded, my lord. But my point is this, because since they are saying that no, we are following as per the roster, so you got ST, therefore now it is reserved for SC. You do not fit into.
It cannot be that, because if we are floating recruitment against UR unreserved post,
yes,
doesn't matter if ST, OBC, SC,
right,
or whatever LGB, whatever is recruited against that post.
Right.
Finish.
Yes.
That's unreserved.
Yes.
It's open to all.
Yes.
Now you can't say that once an ST candidate has been appointed to an unreserved post, that the ST quota which should be there for the other posts are still up for recruitment will die out. That is not a case. That cannot be accepted.
This is what they are doing, my lord.
This totally violates Article 14.
Yes, my lord. This is what my pleadings are, my lord. I'm grateful, my lord.
Yes.
Because now you cannot do it, because just because under an unreserved seat I got one of my ST brother got a seat, or the next you will directly reserve for SC, OBC. You cannot, my lord. This is where the impugn.
If the first election, then it will be only against UR.
It's only UR,
go
right,
from the roster.
Yes,
that's all.
That my lord.
Yes.
So now, my lord,
but the pleading is there in your petition.
My lord, these pleadings, my lord, since I have taken the points, my lord, it has to be, my lord. I'll just point out.
You're not developing your points as the case has gone on.
No pleading, sir.
Pleading should be a categorical pleading.
My lord.
And the first selection The post advertised was 1 UR. Petitioner, he was place number 3. Now second round, for the ST, there's been no more allocation of any all to quota, which would have made him eligible. But he had applied against UR, I'm eligible against ST, whatever.
My lord, I'll reply to that queries, my lord. Just give me some time, my lord. As it's, my lord, those are my points that are, my lord. The queries have.
You advanced that argument.
Yes, yes, my lord.
So you have to back it up with the pleading is to be a writ petition.
Or my lord.
You want to post another day?
Let it be tomorrow, my lord. We'll just finish it.
Let me finish, then he can.
No, we can't finish unless he satisfies the court first. Otherwise, if he cannot satisfy the court, there's no need for you to argue also. Maybe. Yes.
So let's
there can be any kind of
my lord.
Situation.
Yes. Let's continue tomorrow, my lord, a supplementary, my lord.
Tomorrow, Thursday.
Thursday, my lord. Because then if it takes a long time, then again, my lord.
Yes, okay.
We continue tomorrow again.
You've been praised that the matter be taken up again tomorrow to enable him to prepare the matter further.
And show the pleadings.
Oh, yeah, definitely. Yes, sir, this tomorrow. Let's see what happens tomorrow.
My lord.
65.
Although you should collate the points in a very clear fashion.
Clear, my lord.
It should be distinct.
My lord.
So then you don't repeat the arguments also.
My lord.
So what happens here is that, they're just rambling around. But if you collate the points 1, 2, 3, 4, then you finish at 1 point, like that, then you go to the next point.
My lord, I'll try to submit my bullet point of argument also tomorrow at the same time.
That is fine, bullet points or whatever points, but at least when you place your arguments, so the court also can, appreciate your argument.
My lord.
Appreciate the case here.
My lord.
65.
Much.
This is that matter regarding the clubbing of scheduled castes and scheduled tribes in that residual 5%.
That's not the matter arbitration hearing which you pass over time being, where I think, where's Mr. Kiwi Halindo? That matter is ready. Since RP journal is ready also. Yes. What about that? What's the name of that case?
Manuel.
Manuel, yes.
Yes, my lord.
Yes, for admission, correct?
Yes, my lord. If your lordship will see the order of your lordship, you see on the
let the file come.
issue of maintainability, my lord.
Right.
I take your lordship to the order of your lordship. Kindly give me a moment, my lord. Just sorry.
One petition against three orders of the speaker. That is what you have. But that's the first. That's the only thing you have to argue now. How you can sustain the petition.
Yes, my lord. Lordship, I have the order of the lordship for your lordship 3rd March 2026, my lord. The order is of 25th February. 25th February 2026.
Yes.
Lordship, if I may open my petition and satisfy my lords about the maintainability, because essentially this writ petition, though has challenged 4 disqualification orders by the speaker, it has from the same set of facts involving the same question of law. The question of law being that whether a merger can be approved without approval or without consent of the original political party. For this, my lords, I will have to take you through the facts of this case.
I'm sorry, because I have raised the issue of maintainability. I have a right to raise that argue, then thereafter Mr. Arnav
So
can
this is my
reply.
petition. If there is a maintainability point, then I should be allowed to at least justify
First I have to
why I have prepared the
argue.
petition in such
First
a
I
way.
have to place. No. First I have to place what is my objection. Then thereafter, Mr. Arnav, you will reply.
Yes.
That is, whenever preliminary objection is raised, I get the right to argue, and then you have to satisfy.
Then you reply to yes. Yes.
Because I am raising that. Yes.
They have raised
Very
that
well,
point.
my lordship,
Let him start. Let the
This is my
application start.
petition. That's why I was.
Yes, it's your petition, but if a question meant to be has been raised, since and you have to satisfy the court that's maintainable before we can proceed further. Yes, you start.
Yes, actually, we have the order, my lord.
Order dated.
This is lordship has fixed the issue of maintenance.
Where's that order?
Lordship will see that order, my lord. It is
In the miss case or main case?
Is in the main matter, my lord. Lordship has fixed the maintainability issue, my lord. In that matter will be heard on maintainability. And the lordship has said so in the order of 24th March 2026, my lord. Now, I'll take your lordship to the relevant order at relevant point of time.
Yes.
But kindly have two facts, my lord, before your lordship, is that your lordship will see the order, my lord, is first order is the disqualification petition which was filed, my lord, at page 159, my lord. Page 159. So this is lengthy petition. 159, the lordship will find that two disqualification petitions were filed. Two disqualification petitions were filed at 159.
Yes.
The lordship has page 159, where the lordship will see this is the petition filed by Miss Sri Roni V. Lindo, my lord, page 159 at the top, my lord. And after that, if the lordship will see petition under 6 of Meghalaya Legislative Assembly for disqualification of 2 members, my lord. That your lordship will find at page 161.
Yes.
Lordship, Sri Gabriel Wallan and Charles Mangler. These are the 2 MLA whose disqualification was sought by the petitioner Roni V. Lindo, my lord. Right. Then, my lord, at 175, my lordship will find the another petition filed by Roni V. Lindo for disqualification of the lordship will have
Stein Lindo.
125. In 175, the lordship will find the Mr. Roni V. Lindo has filed the another petition, and this petition is for disqualification of Mr. Celestine Lindo. This was the petition filed, and your lordship will mark the dates of these 2 petitions were filed on 9/9/2024 and 16/9/2024.
9/9/24 and
24 and 16/9/2024.
Okay.
9/9/2024 and 16/9/2024.
Yes.
And the lordship will kindly come to page 191 now, which is in the 191, your lordship will find the order of the speaker dated 15/10/2024. 191. Lordship will have page 191.
Yes.
And the order of the speaker, my lord, is at page 15th October 2024. And the order says, whereas petition seeking disqualification bearing cause title of so and so versus dated has been filed by Sri Roni V. Lindo seeking disqualification of Sri Gabriel Wallan, MLA Nonstein and Sri Charles Mangler so and so, whereas the petition has been filed for in violation of Para 2(1)(a) of 10th schedule of the Constitution, whereas this petition for disqualification is required to be examined by undersigned in terms of sub-rule 1 of Rule 7 of Meghalaya Legislative Assembly Disqualification Rules 1998, whereas the instant petition seeking disqualification in terms of sub-rule of Meghalaya Legislative Rules 1998, whereas upon examination it has been found that petition seeking is defective as in filed in violation of Rule 6 of Meghalaya Legislative 1998, the relevant defects are enumerated. petition for disqualification is in contravention of Rule 6 of seeking disqualification of more than one member of Legislative Assembly through single petition. Our Meghalaya Legislative Assembly disqualification rules do not permit challenge to membership of more than one person through a single disqualification petition. The petition is filed in violation of the format contained in Form 5. Certification, we are not concerned with this part, my lord. Only we are concerned with page 191A, my lord. Lordship has 191A, my lord.
Yes. There should be 5 separate applications will be filed.
Am I audible, my lord?
Yes, you're audible.
Yes, my lord. 191, my lord. So this is the order passed by the learned speaker on 15th October 2024, saying that by one petition you cannot challenge the disqualification of more than one member, and it is not maintainable because it is not in format, my lord. This order, my lord, was accepted by the Congress party, my lord, Roni Villindo, my lord, who is representing Congress party, then representing Congress party, my lord, and separate, your lordship will kindly have page 195. 195. Separate petition was filed for Charles Magnet at page 193, my lord. You lordship will kindly note the period, my lord. 193.
Yes.
Which are dated 18th October 2024, my lord. Mr. Gabriel Wahalan, page 210, my lord. Separate petition for Mr. Gabriel Wahalan, page 210, my lord. Lordship will have separate petition. So the plea, the petitioner accepted that petition has to be separate for each MLA, my lord, before the Honorable Speaker. 210, your lordship has 210. And the memo parties you lordship will find at 212.
Yes.
212. So separate petition was maintained for each of the Honorable MLA, my lord, and 232, my lord, is the third petition.
Yes.
232, your lordship will find, and all are dated 232, your lordship has 232. Yes, my lord. So all are dated 18/10/2024, my lord. So the submission which I am trying to make on the basis of their own conduct, my lord, is that they accepted the order of the Honorable Speaker dated 15/10/2024, that the order, there cannot be a common order or common application seeking to disqualify the petition in terms of rule, relevant rule of disqualification provisions, my lord. Lordship have 232 also at page 232. Mr. Roni, these are the three petitions, my lord, filed. Now, my lord, this petition was dismissed by the Speaker at 2:46. These petitions were dismissed. Subsequent petitions were dismissed at 2:46, my lord. Lordship will have 2:46, my lord, and I'll place that order before your lordship. Whereas petition seeking, my lord, 2:46. Whereas petition seeking bearing cause title Roni Villindo has been filed by Roni with disqualification Charles Magnet and so and so. Whereas petition has been filed for violation of 2(1)(a) of 10 schedule. Whereas this officer, through order of 15/10, intimated to defect and contravention of Legislative Assembly rule in respect of petition dated 9/9. Whereas thereafter instant petition has preferred by Roni Villindo on 21/10. Whereas the petition for disqualification is required to be examined in terms under Rule 1 of Meghalaya Legislative Assembly Rules 1998. Whereas instant petition seeking disqualification was examined in terms of Sub-Rule 1 of Meghalaya Legislative Rule 1998. Whereas upon examination, it has been found that petition seeking disqualification is non-compliant of disqualification rules 90 and has been filed a rule so and so. The relevant contraventions are enumerated below. The petition is contravention of rule. Is filed in contravention is to petition shall also be authenticated and signed by petitioner. Annexes are neither unauthorized nor authenticated petitioner. Therefore, same does not amount to compliance of the rule so and so of 1990. Petition is also in contravention of rules of Meghalaya State on the ground of defection rules as signature of petitioner are not verified by notary and all. Now, therefore, in the light of rule contravention of filing instance.
So on technicalities, it was not entertained.
Yeah, the Speaker dismissed the petition, my lord, which your lordship has filed on 25th October 2025. The point
This is
I was making,
25th/02/25, correct?
25th February 2025, my lord. Order
Yes.
was passed in respect of each of the petitioner, my lord. Your lordship has the 2025. Now, my lord, the 248 is the second order. 250, then my lord, 250 is the third order. These three orders were passed on 25th February. Against this, my lord, the writ petition was preferred by Congress party through Mr. V. Lingdo. Sorry, Congress party through Mr. Roni V. Lingdo. That you will also find at 252. Now 252 is the writ petition filed by Congress party through Roni V. Lingdo, my lord. And if you lordship will see in this petition, my lord, the petitioner had challenged the very same order of 25 to 2020, and the memo party, if I take your lordship to the memo party, my lord, which your lordship will find at page 268. 268 is the memo party, my lord. And name is, my lord, the Charles Margaret Gabriel Wallen, 269, and Celestin Lindo, my lord. Your lordship has
Yes.
got the page
270. Yeah.
Yes, my lord. This petition was filed, my lord, and this petition was, my lord, was withdrawn, my lord.
Because the petitioner also jumped ship.
Oh, yes. Yes, my lord. The lordship is right. That this was, my lord, and this was withdrawn, and it was in fact this I have already shown, my lord, that those disqualification petitions fresh was filed. They filed initially one combined disqualification petition, which was returned to them. Then on 18th October, fresh disqualification petitions were filed, which was dismissed by the Speaker on 25th February, and writ was preferred, my lord. And at page 300, my lord, you also will find the order of the lordship dismissed as withdrawn. The 300.
Page
300 is the order of your lordship of 13th August 2025. Lord. Now the order, if your lordship will find that order, my lord, the order is where the withdrawal application was moved, my lord. If your lordship will see 301.
Yes.
This petition closed and disposed of on withdrawal. Your lordship has page 301.
Yes,
the
yes.
order of your lordship is dated.
Yes. Then again, a fresh one was filed 202.
Yes. So 13 August. Now, my lord, 302, your lordship will come to 302. Now, again, separate petition was filed. By this time, by the petitioner before your lordship.
How long did the matter remain pending? The other petition, when was it filed? When was it withdrawn?
It was, if your lordship will see,
filed on?
the petition was preferred in April 2025. Lord. The order of the speaker was first in the first round. Order of the speaker was of 25th February 2025, 25 to 2025.
And April 13/8 and 13/8/25 was the withdrawal. So till that time, the matter on maintainability was not taken up at all.
It was taken up, my lord, but
you filed for the speaker.
No. Like when it came for this court, one petition like today has preferred against 3 MLAs, correct?
Yes.
Now at that point of time, was this point taken up or not on maintainability?
No, it was not taken up at that time.
Okay.
because my lord, at that point of time, my lord, I'll place the order sheet of the previous matters, my lord. They did not even in fact, in these matters, my lord, I'll place the pleading of that matter also before your lordship and order sheet, so that your lordship will have complete record of the matter, my lord. So then, the point I was trying to make, my lord, that when the speaker raised the objection that you cannot maintain a single petition for rejection of or the disqualification of all MLAs.
No, when they came to this court, when they came before this court, Mr.
This objection was taken, my lord. If I will place that record also,
and that's important, whether you raise it at that point of time. Yes.
No, my lord, we have that. I will place the record also. It will also because I'll place the all orders of.
It was pending from, see, it was filed in April 25 and it was withdrawn on 13/8 and it's August. Then?
Yes, Lordship is right. I will place the relevant records, my lord, of the, if you lord, every petition, my lord, the reply or the order sheet also, because that is required for completeness of the record, my lord. I will place it, my lord. Kindly give me 1 week time. I will place all the relevant orders in the previous proceeding, my lord. I will do that, so that your lordship will have all the records.
So before we embark on a detailed hearing, we have to see whether they raise this question at all.
Yeah, there was occasion to raise that question also, my lord.
Didn't have occasion to raise it. You must have raised it.
Yes, my lord. If your lordship will see, there was no occasion also, my lord, because in that meantime they virtually abandoned the petitions, my lord. From April to
Lordship, I may have an objection to that. I have an objection to the fact that we have withdrawn or abandoned that petition. I'm sorry I could not appear on the first call, Your Lordship. The fact that we have...
Who are you appearing for whom?
I'm appearing for the petitioner here, Manuel Banra, Lordship, in this particular item number.
Where's the other person disappeared who was here just now? Was making objections?
Yes, he's with me only. He's with me. I had authorized him.
Oh, he's there in another...
He's with me, yes. Yes.
Another frame, yes. Because very confusing, yes.
I apologize for that confusion in that regard. Sorry, I missed it, Lordship, on the first call. I understand now on learned AG has that place the orders on record. I have no objection. Next week I'll take it up. But on the maintainability, Lordship, I wanted to also mean this is not a simplistic matter about procedural infirmities. This is a constitutional issue which has come before this Lordship. Now what has happened is they completely set across the defection aspect. And then the best part, and this is where I say that, Bardon, this is the first time we are seeing it, one of the petitioners has actually committed the same sin which he was praying against. And then he's become a part of the respondents now. So it cannot be about the abandonment in any way.
I'm sorry, Mr. Huda, you were not there when I started the argument. My preliminary objection is being heard. Then thereafter...
No, I completely understand. I only objected, sir, when you said that this was abandoned. It was never abandoned. Because that person...
Okay, fine. Please. Okay, we will post it after 1 week because we have other matters to pick up. Yes, just for further hearing after 1 week, Advocate General to produce the relevant orders passed in the earlier petition. Yes.
This is a specific first objection taken in the last.
Mr. Pandey, you also, Mr. Arfijan submitting. Now you also submitting, please. Thank you. This is
representing respondent number 4.
Right. Okay. Oh, sorry. Okay. Separate respondent. Yes. You have something to say also.
65.
I'm accepting the same.
Highly obliged.
Grateful lot. Yes. Where's Mr. Snaitang? You won't take up a matter then. You've not been able to file it.
Actually, we already filed it.
Then show me the file then.
She was in the process.
Okay, next matter is Lakhan Prasad. Yes.
This is that issue about the clubbing of scheduled castes with scheduled tribes in that residual 5% quota in the reservation policy.
Clubbing of
scheduled castes and other scheduled tribes, leaving aside the dominant tribes, that's the Khasis, Jaintias and Garos. Because as per the reservation policy, allocation is this way: 40% for Khasi Jaintias, 40% for Garos, 15% for the general category, and that residual 5% is allocated to the scheduled castes and the other scheduled tribes under Article 341, that list which is prepared. So both these entities...
You're contesting the 5%?
5%, my lords.
You are a scheduled caste?
Scheduled caste.
Not OBC?
Not OBC.
But there's no OBC list in Meghalaya?
There is no OBC list.
Yes.
So we only have a list under 341, that is the Constitution Scheduled Caste Order 1950, and under 342 is the Constitution Scheduled Tribes Order 1950. In the Scheduled Tribes Order, the three dominant tribes are the Khasi, Jaintia, Garo. They have their allocation of 80%. And we have been allocated 5. So entire scheduled caste list, finds place in that 5% in combination with whoever's left over from the list of 342. The other scheduled tribes, Koches, Rabhas, etc. Well, the short facts are this. The NPAC had advertised a total of 35 vacancies to the post of Meghalaya Civil Service Junior Grade in July 2023. By applying the reservation policy, 2 seats were reserved for this 5% for joint competition by the scheduled castes.
Again? Now,
35 were advertised. Total number of seats were advertised.
Okay.
And of that, if we apply the reservation policy and we apply this 5%, that quota works out to 2 seats.
Other scheduled tribe, and
scheduled castes.
Okay. 2 seats.
2 seats only.
Okay.
So he applied and he qualified through all the selection rounds, but his name did not feature in the select list. And in the select list, for those 2 vacancies, only 2 people from the scheduled caste community, scheduled tribe community were selected, and he was left out.
From the other scheduled tribes.
Other scheduled tribes. Their names were featured.
Yes.
And his name was left out.
When was this selection held? Or this?
The final result was declared on 17th of January 2025. Last year.
So they finished their training and already in service, that means.
They're in service.
Yes.
This is revealed from the affidavits that have been filed.
Okay. Who's the private parties? You have private parties also?
Yes, Mr. Sheikh is appearing.
One lordship, because he has not made party to the other candidates.
It's not required. I'll explain, my lords. Because I'm saying if there is an equitable distribution, I have to only compete against one party, not both the parties. I'm not saying
picking him
because he's number 2 in that list.
No, but then who, and marks wise, who did better?
He did better. She did better than me, fared better than me.
So in that list, you're number 3, that means.
I'm not in the list, but if had I been in the list, I would have been number 3. I'm outside the 35. Had it been an equitable distribution where one is allotted to scheduled tribes and one is allotted to scheduled castes, then I would find my name featured in place of hers.
You're the only scheduled caste candidate.
I'm not aware of that much. I'm not privy to that information. I don't have that information. It's not revealed in any affidavit as well. How many scheduled castes?
You have to ascertain that, because you see,
yes,
the thing is that you should be the eligible candidate. If from the 2 seats, one had been kept for scheduled caste, one for other scheduled tribe.
Correct. That is correct, madam. But they don't say that in their affidavit that there are some other eligible candidates, and because of that I lack locus. They don't say that in their affidavits. So, my lords, being aggrieved by this whole allocation mechanism, I made a representation to the state government. State government writes and tells me that look, this 5% is a combined category for scheduled castes and scheduled tribes, and it is for joint competition between the 2 of you all. This was never to my understanding, and they say this is the mandate of the reservation policy, that this mechanism works in this way. I was under the understanding there will be equitable distribution, but they say no, this is a combined category for the 2 of you all, you will have to compete in this category. So aggrieved with this, I filed this writ petition challenging the reservation policy insofar as it combines 2 distinct categories and asks them to compete together. So now the question is whether this clubbing of scheduled castes and other scheduled tribes into this common pool of 5% has a constitutional basis.
If you go to division bench then?
Well, I'll leave it to your lordships. But this is again never been raised. Because I'm not...
It's a very interesting issue.
I'm not saying that it should be declared ultra vires. I'm just saying that the internal distribution mechanism is unfair.
No, but you're challenging the resolution or the reservation policy, correct?
No, not asking to be set aside. Just to say... No,
just... It's not even sort of a clarification also.
Lordship.
But that has been done. The action of these state opponents they've resorted to that.
Lordship.
That they've treated scheduled caste and other scheduled tribes as if they are one category.
We've homogenized the 2 of them together.
Right.
Lordship. And most interestingly, there is no single decision on this particular point. There is a passing mention of this whole mechanism in Indira Shawni. There they say that scheduled caste, scheduled tribes and OBCs, if they put together, what might happen that the OBCs will take over all the seats and they leave the scheduled caste and scheduled tribes high and dry. And they say, so therefore there is a need for subclassification. So we are saying it was originally understood that the list under 341
from the constitutional viewpoint, right? From the root, with regard to what is the purpose and purport of reservation.
Yes.
And then you have to look at these 2 categories as distinct.
Correct.
Especially in the sense of their what do you call it, the opportunity.
Lordship.
Those are the kind of things.
Lordship. And well, it's interestingly, we find a lot of guidance.
Where is that executive decision? In the policy itself, that 5% will be.
Yes, but very interesting. The policy, the recital of the policy says it is based on, it is consistent with Article 14. It says, Article 16, Sub-Article 4, it says, this is to address the issue of inadequacy of representation based on the population of the scheduled castes and the scheduled tribes. So therefore, they must have had empirical data.
Look at the population of scheduled caste. That means you have to do that inquiry also. Other scheduled tribes,
Correct.
how many are here, and how many other scheduled tribes are there? Scheduled castes are there.
So, Manoj, this is very important. This is one of my arguments. The state's affidavit does not make any reference to any empirical data or quantifiable data as to what was the reason for clubbing these two together. What was their representation prior to 72 or at the time of conception of this whole policy, or in the last 30 years, do you have any data to show that there has been fair representation of these classes in the services of the state? Very recently, a constitution bench in Davinder Singh says that this list under 341 is not a homogeneous list. Scheduled castes by itself are not homogeneous. There can be further subclassification if in the opinion of the state they feel that a particular class is more backward than another. The state maintains that the scheduled castes...
classification within classification.
Yes. Now what the state does, they say, we borrow you from this class and we borrow somebody else from this class and say you are homogeneous. And they say that in their affidavit, just one line in their affidavit on merit. That's the only thing that they address. That the reason why we have done this mechanism is for the collective upliftment of two people who are similarly situated. We are not similarly situated at all. What is the rationale behind this? Where is your data? So there is no reference to any material or any data in their affidavit to say that we are together. We are similarly placed. They only say you are similarly disadvantaged. So that way the Khasis, Jaintias, Garos are also similarly disadvantaged with the rest of the list. But you subclassified.
Exactly. I was going to come to that. So, and what is...
So you have performed a subclassification before Indira Shawnee. Indira Shawnee came in 92. This subclassification was done in 1972. Now, what is the reason? What is the constitutional basis for you to say that I am similar to somebody else from a different list under 342? These are two different mechanisms, constitutional mechanisms. How can you club us together? Their affidavit does not speak of it.
The latest judgment allows, because that question was there. Now, whether you can make distinction between scheduled tribes themselves, right? So that was more backward. That is fine. So now the courts answered that that is permissible.
Yes.
But what you are arguing is that there are two distinct classes.
Two distinct classes.
That can be permissible.
Yes. So, Manoj, I must also say very fairly, Article 16.4 does not say it's not permissible. There's no prohibition in the Constitution anywhere. But again, there has to be some sort of a reasonable nexus with Article 16.4 that the objective is representation, reservation, equitable distribution and substantive justice, substantive social justice. So in light of that background, what is your constitutional basis for clubbing us together?
Very interesting.
That's the only issue. Now, there is no data before us. Because Davinder Singh also says that for the purpose of Article 16.5, reservation and promotion, the state has the right to make subclassification. They also have the right to collect data, quantitative data. In this case, we had filed an RTI to the state, asking a very simple question. The query was, what is the representation of the SCs in the services for the last 30 years? The state's response is nil, NIL.
Nil.
Nil. This is the state's response. Now, Davinder Singh goes a step forward and it says, apart from the issue of subclassification, etc., what the state has to ensure fair and proper representation of all the identified classes. Now, your recital in the 1972 policy itself says that I suffer from inadequacy of representation. Then the question is, in this 5%, firstly, you've clubbed it without any internal distribution mechanism. Should you not therefore address it? Should there not be a periodical review to address this inherent injustice and ensure now? So they recently had a review alert.
That wherever there were recruitments before,
Lordship,
where that 5%, it was occupied by other scheduled tribes all the time.
So they say that nil. This is their answer. Even in the affidavit, I would say that they would have said something contrary. They would have informed the court that no, we have data to show that SCs have found place.
The inception of the state.
Yes.
So in all the recruitments, so scheduled castes have not figured at all.
In the civil services. Meghalaya Civil Services.
Civil Services.
The affidavit is silent about it, but the only thing we have is the RTA which says nil in 30 years. So now where is the social justice in that? And that's the only question that we are seeking. So therefore, the question is now, which has never been answered by any court.
Yes.
Never been raised before. In fact, fellows, union has specific reservation guarantee for both these classes. All other states, barring state of Meghalaya and possibly also Manipur, if I'm not wrong, they've clubbed it. So this has never been questioned. Now, there is a judgment of the Guwahati High Court relating to the state of Meghalaya on something similar. They say that this cannot be done. You must maintain two different lists, but it is in the context of appointments. I'm referring to. Nine. This is a 1992 2 GLR 195. It's a very short judgment. May I just read this?
Yes.
This case relates to reservation of seats in the matter of selection by the government of Meghalaya for admission into graduate course in the medical colleges. The record produced by the government of Meghalaya indicates that at the relevant time, the government of Meghalaya reserved 2 seats for scheduled castes and other backward classes clubbed together. 2 candidates belonging to other backward classes, namely so and so and so and so, were selected by the government of Meghalaya. There were 2 other candidates belonging to scheduled caste, namely so and so and so and so. In the merit list, so and so was at serial number 4 and so was at serial number 6. Lipika Das has filed this application under 226 of the Constitution of India, challenging the manner of reservation made by the government of Meghalaya. Her case is that the reservation for candidates belonging to scheduled castes and other backward classes should have been made separately, not clubbed together. Article 46 of the Constitution runs, promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. The state shall promote with special care the educational and economic interests of weaker sections of the people, and in particular of the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. Now please see the next paragraph, para 3, the 8th line from the bottom. It begins with in the present case. In the present case, no candidate belonging to scheduled caste has been nominated because the reservation for the scheduled tribe and other backward classes was clubbed together. If there was separate reservation for each of the communities, at least one of the candidates belonging to scheduled caste would have been selected. Non-selection of any candidate belonging to scheduled caste having the requisite qualifications is against the directive principle of Article 46. The next question which arises for consideration is whether this court shall have the jurisdiction under Article 226 of the Constitution to direct the government of Meghalaya to reserve seats for the scheduled castes and other backward classes separately. We are of the opinion that directive under Article 46 is constitutionally binding on the government in the matters of legislative as well as administrative action. Therefore, this court has jurisdiction to direct the government in this regard. Then please see para 6. For the foregoing reasons, the petition is partly allowed. The government of Meghalaya is directed to make reservation of seats for the candidates belonging to scheduled castes and other backward classes separately in the matter of selection for admission into the medical college. This is only with regard to a point, but the question is the same. Can we club these two together? My lords, I will take your lordships to both Indira Shoni and Davinder Singh. Indira Shoni being the first judgment of its kind, and Davinder Singh being the most recent one.
Case of a division bench. What, Mr. Arvind Chandra, what do you say? This matter needs to be taken by the division bench. It's constitutional matter having a ramification on the state reservation policy.
Yes, but the lordship may not be required to.
Not required. See, the thing is that if the resolution is faulty, then it has to be corrected. There's 2 third categories. In the first blush, looks like that.
Lordship here matter on lordship feel that it requires adjudication by division bench, your lordship may place it before division bench. But that, if once I place my argument, your lordship will see that occasion may not arise. Let me place my argument, then thereafter lordship.
May I just, before that?
Okay, let me just then conclude.
I understand what will fall from the state because the state, my lord, has taken up a threefold objection to this.
Yes.
The first, my lord, will just take the affidavit of the state. This is by, and interestingly, my lord, the MPSC and the state file this. Just state is representing 1 to 5, that is including MPSC, and MPSC has filed a separate affidavit. There are 2 affidavits from MPSC. Yes, yes. 1 to 5.
You must have written 1 to 5.
Yes.
Anyway.
Well, it's 4 and 5 are separately before you.
It happens sometimes.
Now, my lord, the 3 objections on maintainability that have been raised by the state. One is that since a litigant has participated in the selection process, he cannot turn around and challenge it. This is settled law. Second is that judicial review in policy matters is very limited. No, I'm just pointing out what they have said, and I'll just take your lordship to the relevant paragraphs. And the third is that courts cannot issue mandamus to the state to provide reservation to a particular community or a particular class. Now, let's please see their affidavit, page 2, para 4. Affidavit filed by 1 to 5.
Page 2.
Page 2, para 4.
Yes.
That it is submitted that the outset that the writ petition is not maintainable either in law or in fact. The petitioner herein after having participated in the selection process has no locus standi to challenge the recruitment process. Please note that. What do they say? To challenge the recruitment process. I am not challenging the recruitment process for the post of Meghalaya Civil Services. That it is most humbly submitted that the petitioner, having accepted the terms of the advertisement, cannot challenge the results upon finding himself unsuccessful in the said selection process. Again, I am not challenging the selection. I am challenging the distribution mechanism. Now, please see the judgments. Several judgments have been referred to here. The first is State of Meghalaya versus, State of UP versus Karunesh Kumar. Now, we'll just see the last part which has been emphasized in para 3. It is settled law that a person having consciously participated in the interview cannot turn around and challenge the selection process. Again, I'm not challenging the selection process. The next judgment referred to at para 4. What has been emphasized? Thus, the petitioner took a chance to get themselves selected at the said oral interview only because they did not find themselves to have emerged successful as a result of their combined performance. Both at written test and oral interview, they have filed this petition. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to them, he cannot turn around and subsequently contend that the process of the interview was unfair or the selection committee was not properly constituted. Neither case, in my case, this is not what we are raising. Then please see the next paragraph. They've extracted a judgment from K.H. Siraj, para 73. The appellant petitioners having participated in the interview in this background, it is not open for the appellant petitioners to turn around thereafter when they failed at the interview and contend that the provision of a minimum mark for the interview was not proper. Not my case at all. Again, then please see the next page, para 5. The second paragraph. It was further contended in so-and-so para 34. There is thus no doubt that while question of any estoppel by conduct would not arise in the contextual facts, but the law seemed to be well settled that in the event a candidate appears at the interview and participates therein only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or there was some lacuna in the process. Exactly. All over. So there are multiple such things. Now, the
fashion, the draft affairs all like this only.
Lordship, so it becomes taxing on us, it becomes a little taxing on us. Then please see para page 11.
Maybe there's sometimes to navigate. You get very cumbersome and tiresome.
Lordship, please see page 11 then. The next point. Page 11 is judicial review. Page 11, para 9.
Yes.
That it is submitted that the scope of judicial review in such cases is also very limited since the selection process lies within the expert domain of selection committee, subject to proven allegations of malfeasance or violation of statutory rules, which in the case of the petitioner here has to prove any malefied. This is not my case at all. I am not questioning the selection committee, their constitution, etc. Yes. This is completely misconceived by the state, and they go on with this. Then, my lords,
where the other grounds? Where other grounds we made out?
Now, these are the only grounds that in selection, unless there's a provision, etc.
Objections.
Yes, kindly see the main one.
Where did they address
page 34. Page 34.
Did they address that issue as to why they clubbed it together?
Yes, page 34.
That's what we want to see.
Yes.
Yes.
page 34, please see the answer is in para 22 and 23. I'll just read both. That the answering deponent denies any allegation of arbitrariness in the selection of candidates to the Meghalaya Civil Services within the eligible pool of candidates under the 5% quota. The selection was purely merit-based on the basis of the state reservation policy. The petitioner was considered fairly alongside all the other eligible candidates without any discrimination. That it is further submitted that the existing state reservation policy providing for clubbing approach ensures collective upliftment of similarly disadvantaged micro minorities without causing exclusion. Well, let's please have page 22. Page 22, Roman 1.
Okay.
So again, the selection process is not under challenge at all. And may I just satisfy your lordships on this particular point that I have every right to question this if there is an inherent illegality. Please see 2019, volume 20, SEC 17. Give that.
2019?
2019, volume 20, SEC 17.
Lordship, kindly see prayer at page 22. Prayer at the selection process is under challenge. What my friend
If I'm just allowed to finish, I won't take much time. That's here. Please take page 25.
Yes.
Well, it's preliminary issue. Furthermore, before beginning analysis of the legal issues involved, it is necessary to first address the preliminary issue. The maintainability of the very challenge by the appellant has been questioned on the ground that she, having partaken in the selection process, cannot later challenge it due to mere failure in selection, and so on. Now, this is answered in the next page at para 26. The underlying objective of this principle is to prevent candidates from trying another shot at consideration and to avoid an impasse wherein every disgruntled candidate, having failed the selection, challenges it in the hope of getting a second chance. However, we must differentiate from this principle insofar as a candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct, and its violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless he/she participates in the selection process. Now, thereafter, my lords, please see State of Punjab versus Anshika Goyal. This is also what the state is relying on. 2022, volume 3, SEC 633. Keep this back.
633.
Yes, once. 2022, 3 SEC 633. Thanks.
Para
9.2. So here the state says, below, that in matters of reservation, court cannot issue mandamus directing the state to provide for a reservation. If my lords have it, page 642.
Yes.
In Central Bank of India versus so-and-so, while considering the issue of providing reservation in favor of SC/ST category persons in the promotion, and when Articles 15, 16 of the Constitution of India were pressed into service, this court observed and held that though Articles 15 and 16 empower the state to take an affirmative action in favor of SC/ST category persons by making reservations for them in the employment of the union or the state, they are only enabling provisions which permit the state to make provisions for reservation of those category of persons. It was further observed that insofar as making of provisions for reservation in matters of promotion to any classes of posts is concerned, such a provision can be made in favor of SC/ST category employee if, in the opinion of the state, they are not adequately represented in the services of the state. It is observed that therefore power lies with the state to make provision, but at the same time courts cannot issue any mandamus to the state to necessarily make such a provision. Now the answer is in this extract. Please see placetum E.
Yes.
The line begins with "of course" whenever there.
Yes.
Of course, whenever there exists such a provision for reservation in the matters of recruitment or the promotion, it would bestow an enforceable right in favor of the persons belonging to SC/ST category, and on failure on the part of any authority to reserve the post while making selection promotions, the beneficiaries of those provisions can approach the court to get their rights enforced. What is to be highlighted is that existence of provision for reservation in the matter of selection or promotion, as the case may be, is the sine qua non for seeking mandamus, as it is only when such a provision is made by the state a right shall accrue in favor of an SC/ST candidate and not otherwise. In my case, you have identified me as a class which requires adequate representation, so therefore I meet the criteria. And my lords, the distinction between my case and the state's case is at page 644. Please see Placitum C. This is an extract of a judgment of Census Commissioner, para 25. Interference with the policy decision and issue of a mandamus to frame a policy in a particular manner are absolutely different. The state argues I'm coming forward seeking a mandamus to create a policy. That's not my case. So this is the distinction, my lord.
Yes.
And because there are several judgments, but I think these two answer the fine distinction between the state's case and mine. So if your lordships feel the necessity to place it before division bench, lordships, I'll leave it to your discretion.
We'll have to terminate the benches on 15.
Lord,
Yes, Madam.
may I submit, my lord? Now, your lordship will see, first point which my learned friend has raised, my lord, is that he is not challenging the selection process.
Selection process is a corollary to the prayer number 1 that he's made. It's consequential.
My lord, so there is a challenge. There is a challenge, my lord. Kindly see page.
Oh, he has challenge, of course. That's fine. But then,
so if there is a challenge, my lord, so whether my first question is whether my first submission is whether if you challenge and you participate in the process of selection, when the advertisement was issued, you knew that this is the reservation policy which is going to be applied. And once you have participated and you became successful, now you say that you set aside the selection process. There was occasion for you to challenge before the after the advertisement, saying that this advertisement is contrary to Article 14, 15 section of the Constitution. But once you have participated in selection process, you cannot change the rule. You cannot challenge the rule. You cannot challenge the rule. So therefore, to say that I did not challenge it, my lord, it is completely on the wrong and erroneous submission on the face of record. Kindly have the page 22, my lord, for my satisfaction. And paragraph 2, my lord. Small Roman 2. Issue rule calling upon the respondent to show cause as to why final result hearing number dated so and so for Meghalaya Civil Services Junior Grade appointee should not be satisfied, why clearance should not be appointed. So he challenging the result, my lord. And to argue that I did not challenge it, my lord, I fail to understand how can you
anyway,
argue when you...
we'll hear you again.
Yes, I'm grateful.
That is why in view of his submission that prayer has to go, lordship.
No, I'll satisfy, lordship. I'll satisfy.
You have to go where?
No, he has to include that prayer, lordship.
And then render it infructuous.
Yes.
It'll be meaningless, the entire exercise.
Yes, where's that matter?
I'll leave lodgement. Just keep it.
We'll take it up when next?
That's at the earliest. If lordships are subject to your lordships, if lordships are inclined to send to the division bench, then that whole process.
Here, since he wants to advance his submissions.
These are submissions which can be advanced before the.
No, he wants to make a case as to why it should not be referred to the division bench. That's all.
Because I want to place it is covered by your lordship's order, covered by Supreme Court, then there is no need. If it is not covered,
exactly. So you on Wednesday the 26th.
Next Wednesday. Very well.
Obligation.
Supplementary 1, item number 1.
Yes, but Thapa, all the
this matter, my lord, pertains to, my lord, the relieving order dated, my lord, 14th of August 2026.
Who's he?
Lordship,
Once again.
the impugn
He
order
is what?
is a manager admission, my lord.
What's a manager admission? What does he do?
He's basically, his job is to, my lord, facilitate admission into the
For
admission.
students?
Yes, sir.
Okay.
My lord, he has been served with his
When
notice,
was he
my lord.
appointed?
He was appointed in the year 2024.
Let's see the
My lord,
appointment order.
Your Lordship will find his appointment letter at Annexure 2, page 20.
Page 20.
Right.
Yes. Dear Mr. Sansa.
That is his appointment letter, my lord.
Now, where's the duration?
The duration, my lord, is given for 1 year, but it is extendable. My lord, may kindly have page, serial number 3.
Okay. Okay.
Now, my lord, there was an extension, my lord, which is at page 23 on February 13th, February 13, 2026.
Yes.
Now, what had happened, my lord, he was appointed in the...
As per recommendation review committee, is it a period for 6 months from... That's already gone today only.
Today, my lord. That's why I was like saying, my lord, there is a tearing urgency in the matter. Now, why I'm saying, my lord, this impugn order will not be sustainable. My lord, may kindly have...
Where's the impugn order?
My lord, impugn order, your lordship will find at page 42.
What are the qualifications for an admission manager? What qualifications does he have?
The qualification, my lord, he has...
MBA also?
My lord, he has, he is a postgraduate.
Okay. Yes, patient, so and so and so. The exam period is due to complete. The committee committee, the director, students, salary review, with that term condition. So,
now, here,
there is a contract of private service.
No, that is okay, my lord. That is fine. Madam, I'm only one thing, my lord. May kindly have page 24. But there was some letter, my lord, anonymous letter.
When was the letter served upon you?
14th, my lord. 14th.
Then today is the
19th.
14th it was served, my lord. Saturday, Sunday, it was a holiday, my lord. 17th we filed it. Yes. 17, 18, my lord, he could not do anything. He came and meet me yesterday evening, my lord. That's why this matter had to be filed today morning.
Where is the page you see?
My lord, page 24, may kindly have.
Yes.
My lord, this is some anonymous letter complaining of certain misconduct, my lord, on my part, my lord. And basing on this...
What corrective action?
Now, here, my lord, what had happened is, I was sent by the institute to Mumbai, my lord, for the sake of admission, to have a admission camp. Now, my lord, what had happened is, as per the instruction of the HR department, my lord, I was told that students who have arrived late at the particular venue should not be given entry. Now, that was done by me, my lord, at the instance of my superiors. Now, my lord, that has gone in bad taste with some professors somewhere whose student had come to that venue for the purposes of admission, my lord, and she wrote this complaint against me, my lord, to the extent of, my lord, saying that he will go to human rights, so on and so forth.
Who's the person who wrote?
My lord, he is a professor from some institute, from some private institute, my lord.
It was written here, has come to my notice that the process began only at 4 p.m.
Right.
If students arriving after 12:15 are permitted and then were humiliated, an explanation is required. Yes, okay.
So, my lord, based on this, my lord, partly, my lord, the institute now, partly relying on this complaint, have, my lord, decided not to
extend your period.
Extend, or my lord, my lord, give me appointment or regularize my appointment. My lord, here what I'm humbly submitting, my lord, if this is a base on which, my lord, this is the basis on which...
Asked to show cause on this?
Absolutely, my lord.
You asked to show cause.
No, they did not ask for show cause.
You're not given any opportunity at all.
Absolutely no, my lord, not
When
at
was
all.
the allegation made? When is this camp held?
This camp was held in the month of February, my lord.
This year.
This year. Of course, my lord.
And this letter, this February 7th, this is the email.
Yes, she has written on two occasions, my lord. One on 5th of February and again on 17th of February, which is at page 26.
So without any process, they've...
Absolutely, my lord. And if what I'm humbly submitting, my lord, if this is a basis on which, my lord, based on which the impugned order has been issued, even if it is partly relied on, my lord, I ought to have been given an opportunity to show cause.
Sure that is the only basis on which service has not been continued.
No, I'm not privy to anything, my lord, because the appointment letter requires, my lord, that they have to base their review on the basis of performance report every year. My lord, that I'm not privy to what kind of performance report they have prepared or made. I'm just given this impugned letter on one fine day, my lord, asking me to relieve.
Yes, Dr. Muzika.
Well, can you see page 20 is the appointment letter?
Yes.
Now, para 3 means probation. You will be on probation for a period of 1 year initially. The period may be extended if found necessary. Thereafter, can't read, but initially on a probation for
at the sole discretion. At the sole discretion of the institute.
This is January 24, my lord. So there has to be January 25 another extension of probation, my lord. That's not available on record. Now page 23, my lord, kindly see.
No, that extension is there.
Yes.
First extension is not there, my lord. 25 January, there has to be one extension, my lord.
This is dated when?
This is 26, my lord. February 26.
So now he was upon 24.
So it is
24.
Must be somewhere buried in the record. How can it continue without any extension?
But it must be there, but because it is not available now. Now, kindly see this one, my lord. What it says. Second extension, my lord. As per recommendation of the review committee, the institute has decided to extend your probation period for another 6 months with effect from so and so to 19th August 26. You are required to improve your performance in the discharge of day-to-day activities in the admissions, especially on the following parameters enumerated, my lord. And now, when 6 months expired, my lord. Now, last sentence, my lord. Your performance will be reviewed against before completion of 6 months for further action on your confirmation or otherwise. Last sentence, my lord. So, on completion of 6 months, my lord, again review was conducted. Page 42, my lord. Let's refer to page 42, my lord. Impugned order.
Yeah.
Para 2, my lord. Based on the recommendation of the review committee and approval of the director of the institute, it has been decided that you be relieved from the institute as manager admissions with effect from the afternoon of 19th August. In accordance with the terms and conditions of appointment, the institute shall make payment of 1 month salary allowance in lieu of notice period as applicable. You are requested to complete the handing over so and so before 18th August. So, my lord, this is non-stigmatic. There is nothing stigmatic in this termination letter, my lord. And it is the discretion, my lord. The review committee assessed the performance, my lord.
It's on probation.
Gave him 2
absolutely. I have no say about it, man. I'm only my only. No, I'm only saying, my lord, if at all, my lord, to review my performance, if they are based on that letter which I had already pointed out, my lord, then I ought to have been given an opportunity to show cause.
It's not necessary,
my lord. And I'm sure, my lord, they've relied on to review my performance. They've relied on those 2 impugned letters, on those 2 letters also. Well, if that be the case, my lord, the principle of natural justice would require, my lord, opportunity should be given to me to show cause as to why that letter
what
should not be even considered.
What employment do you have right now? You're a probationer. Then,
no, my lord, even if I'm in a probation, my lord, the principle of natural justice would have to be applied. I have a judgment, my lord, I can please.
Natural justice now.
No. I'm not saying, my lord, had it been a
vested rights to occupy.
No, my lord, I don't have a vested right, my lord. Had it been, my lord, the relieving letter simpliciter, my lord, I would have understood. But, my lord, the very reason why the institute was prompted to issue this particular letter was triggered by that particular complaint.
Let's see the decision what we have, where you can bring,
well, I'm only
principle of justice into justice into such situation.
I'm only placing this particular judgment matter at para 7. It is a very small, so it is 2003, or sorry,
See,
2000.
out here it says that the appellant failed in performance duties administratively technically.
No, I'm on para 7, my lord.
Besides, the affidavits filed in the High Court, Supreme Court also indicated the background which appellant terminated, held the order, the face of it was stigmatic. That is the thing.
No, correct, my lord. I'm only saying, my lord, what ratio has been laid down in para 7, my lord.
See, stigmatic and punitive. Where? Para 7 is C. A probation like temporary servants are entitled to certain protection. And so it's going to be, yeah, this is fine. It's just, but then read the other paragraphs also.
My lord, if they have based on that particular letter, my lord, it has a trapping of some allegation with regard to misconduct on my part.
Please come back to your extension at page 23. Kindly turn. See, this court has no problems like with, if it's a genuine case and you make out a prima facie case to issue interim orders. But then C23.
No, I'm only saying, my lord, if
February 2020,
26. 23rd of February 2026.
Yeah, see, this is after those letters were received.
Absolutely, man. That is what I'm saying.
After letters were received, they've extended your probation.
Correct.
Suppose the letters were taken to account, you would have straight away said, we are review committee.
No, my lord, that is one of the consideration which they had. Those letters are one of the consideration, my lord, based on which they had they have prepared my performance appraisal.
You say those two emails that came on the 5th and 7th of February 2026, right? By some professor saying that you had committed some irregularities in the admission process. Okay. You just catch those there, 5 and 7. Now this extension was given on
23rd.
13th.
So if that was a valid consideration, the review at that time you said.
No, my lord, it is based on a yearly performance, my lord. My lord.
See, as per the review committee, it said to extend project for the 6 months. See, why should I extend it?
When they review it, my lord, when they reviewed it, that particular letter was also considered by them.
On 23rd February.
No, my lord. While passing the impugn order.
Impugn order comes much later.
That is why.
Understand. See, if it was a case that you were renewed up to 19th August 2026, the emails came thereafter, and so they decided, okay, let's kick out this guy, like that.
No, I quite follow what your lordship is saying.
So the thing is that if it was a valid consideration, it would have figured in the 23rd February extension that you received from 20th February to 19th August 2026.
This was, my lord, based on that particular letter. This was. This extension, even though it is an extension, my lord, it is in the form of some certain warnings, my lord. Why I'm saying that is, my lord, what my learned senior has already read that. See, that you please behave yourself, otherwise we are not gonna.
No, that's not.
I'm not saying that not in direct words, my lord, but may kindly have this. You are required to improve your performance, my lord, in the discharge of day-to-day activities in the admission. If this is not, my lord,
so you didn't improve your performance?
My lord, I have no problem because 2 years, my lord, there was no issues at all. Everything emanated after that letter was put in place.
Interim orders. But anyway,
we'll file
instructions that will come Monday.
But again, my lord, let till Monday, my lord, let there be certain protection. Why I'm only saying this, my lord? Otherwise, my lord, there's no point keeping it on Monday also.
Mr. Thapa, nothing that can be
he succeeded.
My lord, I fully appreciate what the lordship is saying.
You think 226 is so...
It will be reinstated with confirmation, my lord.
No, I'm only saying, my lord. Until, my lord, even if your lordship interferes until Monday, my lord, nothing will not...
Once you have...
Heaven will not fall, at least for them. At least for the institute, my lord, heavens will not fall. For me, my lord, everything will fall.
Institute will suffer.
No, institute will not suffer, my lord. As a matter of fact, I would be doing my job. In my absence, the institute will suffer.
Take down the incident petition. Have been filed assailing an impugned letter / order dated 14/08/2026. issued by the respondent number 4, whereby the engagement of the petitioner who is on probation has not been further extended with effect from 19 August 2026. So, next paragraph, Ms. Esthapa submits that the petitioner who was appointed in 2024 as an manager admissions has been discharging his duties efficiently, and as such was also afforded renewal or extension of his probation on 13 February 2026. However, he submits there has been no further extension which was communicated by the impugn order, wherein it is stated that the decision was based on the recommendations of the review committee that decided that the petitioner be relieved from the post of manager admission with effect from afternoon of 19 August 2026. It is contended by the learned counsel for the petitioner that this has been occasioned due to the fact that there were certain allegations made against him with regard to an admission process in Mumbai, which was conducted at Mumbai by the petitioner,
by the institute, and I was deputed there.
Yeah, institute, by the institute, wherein where the petitioner was deputed to manage the same. Stop. Learned counsel has also taken the score to an email received from certain professor, dated
17th of
dated 7 February, and reminder dated 17th February.
Yes.
Addressed to the director's respondent number what with Dr. Mozik?
Respondent number 2.
Address respondent number 2 with regard to this alleged incident. He therefore submits that it appears that his non-continuance, the denial of continuance in service is clearly in view of these complaints, and that if the same is correct, the petitioner should be afforded an adequate opportunity to defend himself as national justice commands. Stop. Therefore, prays that in interim the petitioner be given some protection and he be allowed to continue as probationer in the post of manager admission. Stop. Next paragraph, Dr. Mozika with the DSGI or with MS Ember Chang, who is present on behalf of all the respondents.
Yes. The only difficulty, my lord, they were read all the respondent director by name, my lord, and he is retired. Some new director has come, my lord. Respondent number 2. DP Goel is not a director anymore, my lord. Only director would have sufficed, my lord. Why they were read by name?
Why you give by name?
All 2, 3, 4 by name, my lord.
Why? Are you attributing malafide?
No, my lord. I'm sorry. This is perhaps an omission on my part. We may be allowed to strike them off, my lord.
The petitions become incompetent.
I'm sorry, my lord. That was
You're not sorry to me, sorry to yourself. Dr. Moses has at the outset submitted that the respondents 2, 3 and 4 without any allegation of malafide against them have been arrayed have been arrayed by names together with designations. He submits that on this count itself, the writ petition will be rendered incompetent.
Because number 2, Mr. D.P. Goyal is not a director anymore.
Yes, further, he submits Mr. D.P. Goyal, Professor D.P. Goyal, who is arrayed respondent number 2, he is no longer the director. We'll give him some allowance. To this submission, Mr. S. Thapa prays that the same was due to inadvertence and that the court be pleased to strike off the names and the respondents be reflected only by designation. So, the prayer of Mr. S. Thapa is allowed, and the names of the respondents 2, 3 and 3 shall be struck off. Stop registry to witness necessary corrections. Next paragraph. On the merits of the matter, submitted letter DSGI that a bare perusal of the impugned order would show that the same does not carry the stigma against the writ petitioner to warrant any opportunity of hearing. It is further submitted that the decision is purely in interest of the institute, taking into account the service record of the petitioner, who has been reviewed from time to time. With regard to the allegation that made by the petitioner that his discontinuance has been occasioned due to the complaints, then Senate Counsel submitted that the same because the extension was given 13th February. The same.
2 extensions were given, my lord. It appears that January 25 must be there. It is not
again,
with them.
the second one is after the complaint. He submits that the same.
Page 23.
Same.
6 months extension was given.
Is incorrect, inasmuch as the extension of probation was allowed even after the said complaints had been received. He thus submits that at this stage no interim orders are called for, and he'd be allowed to seek instructions and to place affidavit necessary. Next paragraph. This court, on hearing counsel of the parties and also on examining the materials as available, firstly notes that the impugned order is not stigmatic or can be regarded punitive in view of the fact that the petitioner is still a probationer and has not acquired any vested right to his post till confirmation. Further is the fact that the last extension had been received after the complaint had been made by the said professor. In the view of the matter, though the question for passing term order is still left open, the respondents are permitted to file objection to the same just after 1 week. Yes.
Otherwise, Malad, the institute will suffer, Malad, because there won't be appointing anybody in my absence. What will happen is, Malad, the institute will go without
admissions going on.
But it is going on a regular basis. But what will happen will institute will go without
1 week,
without a manager in
1 week.
Malad, even if I continue for 1 week, Malad, it won't make any difference to them.
It's not a case. It's not a case.
I'm only saying why I'm saying, my lord, here based on that complaint, my lord, they are casting a doubt.
That's a different thing. Then malified.
No, I'm not saying that, my lord. They are those letters have a my lord, those letter has a trappings of, my lord.
It's not a question of you may prosecute for interval.
Those letter has a trappings of misconduct. My lord may kindly appreciate. Those letters have a trappings of misconduct. If at all they have relied on that letter, my lord, I ought to have been given an opportunity.
Positively.
Yes.
Next day they will come and say that the matter has become infructuous because it has not been extended any further.
It's needless to add the final outcome of the.
My lord, the impugned order shall be subject to the. I have no. My lord, I am not in a position to say anything.
Yes.
And that'll suffice, my lord. I'll
my lord, some kind of a protection, my lord, until the next day. Well, what your lordship has just said.
We can't extend it. You're in probation. Yes. Regarding other hearing matters. Yes.
But the other aspect, my lord, which I forgot to point it out, my lord. Here, the letter which was issued, the impugned letter is not by the appointing authorities, by somebody else. Perhaps that issue will also have to be.
Letter issued by whom?
But the impugned letter, my lord, is not by an appointing authority. Perhaps, my lord, that is also would be.
By it's communicating the decision of the review committees. It's based on that, yes. So it has a company authority, yes.
67. 67.
You've kept your prayer open. That's the most we can do. Yes, Mr. Chaudhary.
May I, Your
Yes, what is this?
This is for voluntary retirement, my lord.
Of the radiologist, my lord.
Not allowed to retire.
On last occasion, I placed instruction, my lord, which says
there's nobody to replace him.
In 4 hospitals, we only have 2 radiologists, my lord. We cannot dispense.
How can a soldier go out being X-rayed?
The thing is that, my lord, actually, this is petition is totally based on pension rules, my lord. And this is very much clear that after 20 years of service.
But the thing is that they have that discretion also to refuse.
Yes, ma'am.
Refuse, but not that ground. Not that ground. Anywhere it is not there in the act.
You won't hear it today. I'm a bit short of time. You bring authorities.
Authorities, because only they are banking their case on the resignation, but my case is not resignation. This is the thing.
Yeah, authorities. You supply them to Dr.
Yes,
Mosik also. Yes. Yes, this is a matter of up to 1 week.
Yes.
68.
Yes.
May I also yes.
Thank you.
No, negative.
Yes. Where is he to?
I don't think they are represented.
Obliged.
Can come.
He's. I'm not sure if he's still in this matter. Mr. Deb.
Who's Mr. Deb?
Sir Swapnil Deb.
Why he's divorced from Mr. Deb?
Yes.
Okay. Yes, this matter after 2 weeks.
Lordship.
You just inform me.
Lordship, I'll inform.
73.
Obliged.
73.
Here he is supposed to bring some instruction, Lordship.
Next date, Lordship. I have the instructions, but.
What's the instructions?
The amount is.
Bank statement has been produced.
Yes, Lordship, yes.
Has been communicated to respondents.
Yes.
What instructions do you have in the bank statement?
It's not disputed, Lordship. But I would like to make some few submissions, Lordship. So, next date.
Additional senior government can submit that. No instructions be received. He prays will have to praise oral arguments on the next date. Yes. When you want to list it?
2 weeks.
2 weeks is a standard here.
1 week also no.
1 week also
because this we can dispose of.
It can be disposed of next day, Lordship.
After 1 week.
Lordship.